Welcome members, this is the 25th meeting of the Committee for Justice. Welcome to our new clerk, Cathy O'Hanlon. Cathy is a veteran of the Committee for Justice, so it's great to have her with us, and we look forward to working with her here as we make our way through the bill and so on. The meeting is now open to the public, so I anticipate that we'll have some people in the public gallery, and certainly some officials are now joining us. Members, the committee is going to be recorded and broadcast throughout Parliament buildings and online. I'll come to the public gallery in a second when everybody's had their seat. Members, it's proposed that the oral evidence session with officials from DOJ on the Department's proposed amendments to the Justice Bill will be recorded by Hansard. Are you content?
Yep.
Thank you. Also, members, we're obliged to declare financial or other interests that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest to wish to declare at this stage? Deirdre?
Yeah, just an immediate family member that works in the court service and also a brother who fosters, so just when we're discussing that issue.
Thank you. And I have an immediate family member who works in the legal profession. Now that everybody who has joined us in the public gallery has taken their seat, just to say you're all very welcome. Thank you for coming. You're also allowed to use your mobile devices, provided that they're in airplane mode and muted. There should be a Wi-Fi password in the gallery rules if you wish to avail of that, but it's not permitted to take photographs or record any of the meeting. Agenda item 1 is apologies. We've got a full house today, so no need for that. And you'll note that the members online are Doug Beattie, Maurice Bradley, Gemma Dolan, Justin McNulty, Deirdre Hargay and Stephen Dunn. Agenda item 2 is the draft minutes. Those are at pages 5 to 13 of your meeting pack from our meeting on the 12th of December. Are members content that those minutes are a true and accurate reflection of that meeting?
Mm-hmm. Yeah, content, yeah.
Thank you. Then I'll sign those. I have no matters arising. Does anybody else? Sorry, apologies, I do have matters arising. Correspondence with an individual, that's at pages 15 to 19 of your meeting pack. You'll recall at our meeting of the 12th of December, the committee was briefed by Clerk Assistant Frank Geddes on a draft response to a letter from an individual regarding issues raised about the Northern Ireland Troubles Legacy and Reconciliation Act 2023 and a number of other matters. We agreed that I, as chairperson, and the clerk assistant would liaise regarding suggested amendments to the draft letter, and then it could then be issued. So just to let you know that the letter was issued to that individual on the 19th of December 2024, who responded stating that his initial item of correspondence could indeed be shared with the Committee for the Executive Office and the Northern Ireland Affairs Committee at Westminster. So this has been now done, and the Northern Ireland Affairs Committee has advised that it will contact the individual. So are members content to note the items of correspondence? Thank you. Item 3.2 then is correspondence regarding K9 Search and Rescue Northern Ireland, and I would refer members to pages 20 to 23 of their pack for the relevant papers. You'll note, members, that this item of correspondence is marked restricted because it has been marked by the sender as without prejudice and in confidence. So I would ask members to be mindful of this if we're going to discuss the correspondence. You'll also have received the correspondence directly from the sender. At our meeting on the 12th of December last year, we considered correspondence from K9 Search and Rescue Northern Ireland requesting that the committee seek clarity on the decision by the DOJ not to approve its application to join the Northern Ireland Search and Rescue Practitioners Group. At that meeting, we agreed to ask the Department for clarification on the reasons for declining the application and a number of other questions. So, the item of correspondence at pages 20 to 23 refers to K9 Search and Rescue and has raised a number of issues. So I'm asking you members if we can agree to note the item of correspondence at this time and to consider it further when we are in receipt of correspondence from the DOJ in relation to our initial letter on the subject. Are members content?
Yep.
Content.
Yep.
Thank you. Agenda item 4 then is the Justice Bill. So we're going to discuss then the Department of Justice amendments with regard to Part 1, biometrics, then restorative justice, then access NI filtering, and then serious organised crime. And we're going to receive oral evidence from DOJ officials. I would ask members to turn to pages 24 to 107 of the meeting pack and pages 3 to 23 of the tabled pack for relevant papers. While the officials are taking their seats, I just want to run through a few bits and pieces here. So we're going to have oral evidence from the officials on the proposed amendments as outlined before. I'd like to welcome Andrew Laverty, who is the bill manager. Andrew, welcome back. Lisa Bowl from the Reducing Offending Division. Lisa, you've been with us too many times. In fact, it's all people have seen before, and you're all very welcome. Veronica Holland, Deputy Director of the Rehabilitation and Reducing Reoffending Division. Katie Taylor, the Deputy Director of the Protection and Organised Crime Division, and Brian Thompson from Access NI. So, folks, as I said, you're all very welcome. We're grateful to have you, and we look forward to hearing what you have to say. Our intention today would be that we move through this in sections. I think it'll focus our discussion. It means we're not jumping back and forward between subject matters. So my intention would be to just take them as they come. So biometrics first, then restorative justice, then access, NI filtering, and then serious organised crime. So I would envisage, if it's okay with you, that whoever's kind of going to kick us off with biometrics, that you give your introductory remarks on biometrics. We'll open the floor to questions on that. We'll round all that up and then move on to the next subject. Is that okay?
Yep.
We have a few questions on each of them, but I just think it's a bit cleaner, keeps us all focused, and we can deal with issues as they arise.
Yeah, completely agree, Chair.
All right, so I'll hand over to you.
Okay, well, I don't personally have any policy content for this set of amendments, but I'm happy to appear before the committee, and we thank you for the opportunity to talk about this particular set of amendments today. I'm happy to address any issues that there might be around bill management or handling or process, including what's coming up next. You've suggested that you'll start with biometrics, which is Lisa, and what I might do, rather than sort of rehearse the briefing papers that you've got and you've had the opportunity for members to familiarise themselves, I have a very high level snapshot that I'm happy to give to you, or if you're happy to just
You go ahead, Andrew, you give us your
not wishing to take away anything from what Lisa might wish to say, I would say that from a bill management perspective, the biometric material provisions don't represent any significant new policy. They're primarily additions to the provisions that were drafted for inclusion in the bill at introduction to ensure that they operate as intended. And that's after the finalised provisions were stress tested in conversation with PSNI operational colleagues. So, as I say, not significant new policy that represents wholesale change, but rather a precautionary approach to make sure that the legislation is future-proof as it possibly can be. So, I'm sure Lisa's happy to speak to the detail of it for you.
Good, thank you.
Okay, as I say, these were just minor amendments that arose as we were working through the detail of the provisions with PSNI, and there's a couple of things that came to our attention that we needed to amend in the bill. So with the briefing paper you've been given, it sort of explains the amendments there in detail. So just to kind of summarise, there was an issue that needed clarified around the use of the term reported through the section of the bill that deals with biometrics, and it was just an issue that needed clarified because the term reported can mean different things as it's used colloquially in everyday life, and what it actually means in terms of a person going through different stages of the justice process. So it was to clarify what that term actually meant in terms of when the police were able to use the powers to take fingerprints and DNA and other biometric material. And it was just to be clarified that it was at the stage that when the complaint is led with the court, and that aligns in with the magistrate's court, the magistrate court order NI. So it's just to clarify that terminology through that section of the bill. We identified a need to. It came to our attention that community-based restorative justice order can be a standalone disposal in its own right. So we just needed to make sure that the retention period for anybody who's given one of those disposals was clarified in terms of over 18s and adults. So that clarification has been made. There were a few changes to sort of clarify time periods as to under 63E and a 63G. Whenever an investigation has been completed, how long, just to clarify, give the police a bit more time before they have to delete the material, just to consider if they need to make an application to the Biometrics Commissioner or to make arrangements for the appropriate deletion, and just to make sure that there was enough time and clarity on that time scale. And at 63G, just to make clear that the police can hold the material until they have the outcome of the Biometric Commissioner's decision. And again, that is just for clarity for the PSNI in terms of the operation of the legislation. And there was also some an addition in terms of the recall powers. There's recall powers that are to be commenced as part of the overall package, and that gives the police the power to recall somebody to a custody suite to have their fingerprints and DNA taken if they weren't taken during the course of the investigation. So maybe if there's been a voluntary interview carried out rather than an arrest event, they wouldn't take fingerprints and DNA at a voluntary interview, but these powers would give the police the police the powers to recall the person to do that. So we've introduced an amendment to put photographs on the same footing as fingerprints and DNA, which is in line with an amendment that's already been made in England and Wales. And we've further clarified that power to give the police the power to actually specify the time and the date that the person has to come back on, rather than a general time window, to give a time and a date so that the process works more efficiently for everybody, so that the police know somebody's coming in and the person knows when they have to go. So it's just to make that provision work better. So that's kind of a summary of the changes being made to the biometrics provisions. So happy to take any questions on any of that.
Okay, Lisa, I've got Deirdre first of all with stuff around retention periods and human rights and stress tests, and then Connie's going to come in the back of that. But could I just clarify then, with regard to the photographs, are you guys now regarding photographs as part of biometric material? It's not specifically mentioned in the bill, I don't think.
No, the bill itself focuses on the retention of fingerprints and DNA. We still haven't reached a view on whether photographs are biometrics. I think in some cases they are defined as biometrics, and in some cases it's not quite clear. And I think it's something it's an evolving thing, and it's something that we need to do a bit of further work on itself in terms of the retention of photographs. But this is about the power to actually just take the image that we're amending, yes. Just the recall power to take the photograph at the moment.
But as you progress in this, I mean, do you envisage making a decision as to whether or not it's considered biometric material before the end of the passage of the bill?
I don't know that we'll come to a decision by that stage, because it's an issue that we need to look at in more detail, and it will just depend on our capacity to be able to do that. And I know that it's something that our counterparts in Scotland and the Home Office are also looking at in more detail, and we want to take account of the work that's being done there and how it's considered, because I know under the Scottish legislation they have quite a broad definition of biometrics, which includes photographs. Home Office position isn't just as clear on that. To date they haven't, but we know that they're looking at that again, so we want to take account of different views and come to a view on that. But that's something that we just don't have. We need to come to in due course once we have the capacity and the time to do that. Our focus has been on the fingerprints and DNA retention initially to address the Cochrane judgment. No,
that's fair enough. Thanks very much, Lisa. Deirdre, I'm going to hand over to you now.
Yeah, no, thanks very much. I suppose just following up on that last point, because these are serious issues that have human rights implications. And obviously there's been a series of court judgments in terms of compatibility with said rights. So I suppose just on that, if no decision, Lisa, has been taken by the department if photos are part of the retention, is it not putting the cart before the horse then to take a power then to take the photos? And are you talking about not implementing that legislative change until you do make a decision on whether photos are going to be biometrics or not?
No, we see that there's the powers to take, and then the powers on, and there's already provision there around the use to which police can police have a power to take photos when somebody's under arrest. So this is just a power to recall someone to take a photo if the photo hasn't been taken during the interview and investigation stage. So there's already powers for the police to take photographs, and general powers about the use of photographs. So that doesn't really affect a decision about whether or not photos are biometrics. I think that becomes more of an issue when you're talking about searching and facial recognition and that sort of thing. So that's something that we need to come to in due course, because there's a bit more work that needs to be put into that. So in terms of the human rights compliance, it's about the police have already said that their policy will be to delete photographs at the same time as fingerprints and DNA are being deleted.
But and I see in some of the documents that the PSNI on different aspects of this, the biometrics in general, have sought legal advice. Has that included human rights advice? Are you aware of?
I'm not aware. I'm aware that they've sought legal advice on various issues. I'm not aware. I can't speak to what their legal advice would cover or wouldn't cover.
But you haven't asked that. Have you probed that with them on the back of the High Court judgments that have already been made on biometrics?
Chair and Deputy Chair and committee members, if it might help reassure you, in the same way as the provisions of the bill were scrutinised for competence advice and compliance and human rights scrutiny purposes, a body of work is going to be commissioned in relation to that same detailed competence advice, including human rights compliance and winter framework considerations from DSO colleagues. So that's a body of work that we'll be doing in parallel with the committee's call for evidence. So should you find it helpful, we can offer you a similar table of rights that have been considered, as we did for the provisions of the bill at introduction, specifically for the amendments.
Yeah, I think that would be really useful because obviously in those court judgments, because my other query was going to be around, do you think that these proposed changes and the amendments comply with the Gauguin judgment back in 2008? And I suppose, have you shared the text of these amendments with the Human Rights Commission as well? And if we could get a timeline or a written response from yourselves then, just around when you're likely to do this scoping exercise via DSO. So just a wee bit more detail on that would be useful as well.
Well, it has launched. The piece of work has been initiated this week.
Okay.
I can't at this stage give you, I'm sort of fearful of giving you an indicative time frame in case it becomes a hard target that we somehow get criticised for missing in the future. But I would say that we're looking towards the end of February for that exercise to be complete. It'll then go into the Minister's office for her consideration and before it would come to yourselves. But it's a piece of work which would ordinarily be required at the point where we're seeking executive approval to table the amendments. But given that the amendments are at such an advanced stage of preparedness and you're due to put them out for publication as part of your call for evidence, we've asked DSO colleagues to expedite that competence and compliance advice process so that you have as much information available to you at the same time as you have the information coming back to you from stakeholders and external interested parties.
Very useful, thank you. And Andrew, just with regard to kind of indicative timings, if we know things are indicative, we'll never come after you for being late if we're very clear that things are indicative.
Well, I'm conscious that I've dropped the ball on a couple of things in the past. The delegated powers memorandum was the big one, so I just don't want to set myself up to be embarrassed again.
That's fair enough, but if we know it's indicative, then we know where we are.
Okay.
Deirdre, you're still
Yeah,
going
the other that was just the rationale around a specific date for people to attend in terms of fingerprints. So obviously what normally would happen is there's engagement with their legal representative to arrange a time and trying to put in legislation a specific date, which is on, what works for the PSNI, I just think would be extremely unworkable. So
No,
I would like to know.
If I can just explain, at the moment the recall power gives the police the power to ask somebody to come back to have their fingerprints and DNA taken within a certain time frame, say within a week.
Yes.
So that's quite a broad span of time. So the time and date isn't being put into the legislation. It's the time that the police can ask the person to come back to have their fingerprints and DNA taken, and of course they can bring their legal representative whenever with them. But it's rather than get the police saying somebody you have to come to us within 7 days. So somebody could turn up and the police station might be busy and they might just not have the time to do it, and the person could be waiting around for ages. So it would work more effectively if the police can say, if you come back to me on Wednesday the 6th at 3 o'clock, then the person knows that they're going to be dealt with at that time, and it would work more efficiently. So that's how it's intended to work.
But what if that date doesn't suit the person? It may suit the police, but it doesn't, because obviously a lot of these changes are coming from a policing perspective.
Mhm.
So is that balanced against the rights of the person that it's going to be engaged with? And I suppose is it proportionate and is it compliant then? Have you stress tested that
Well, well, the reason that the
from that
parties,
perspective, not just from a policing perspective?
I suppose we have focused on it in terms of the police because it's police use of resources and it's the police exercising their power to recall somebody to have their fingerprints and DNA taken. You know, it is a power that the police have. It's a discussion we can have with the police in terms of they might want to think in terms of operationalising the power to call before they specify a time that they can maybe give the person a call first to check that the time would work. That's certainly something we could look at in terms
Yeah.
of how the power is operationalised, so we could pick that up.
That's my concern. If somebody's working, for example, and they can't get out on the time that suits the police, that might suit the police. It might not suit the individual. So are they going to be in breach then
Yeah.
if they don't make that timeline?
I think that
So
would
I
just
can get we need to manage policing resources. I understand that, but we have to look at these things in the round, not just from the perspective of the police or indeed the perspective of the individual. We'll have to look at it in the round. So I suppose it's just an issue I know is likely to come up, and I would like to understand
yeah.
more of the rationale or how it's going to work in practice.
Yeah, it's certainly something that
Um,
we can discuss with the police if this is an approach they might want. It's that's something they would want to think about whenever they're arranging a time for somebody to come back. That they can maybe check with them first. You know, if we ask you to come back on this time, would it suit? And they can arrange a mutual date. So yeah, it's something we can look at.
and a broader one, this is my last one, sorry, Chair,
Deirdre-
in terms of the biometric stuff.
Deirdre, Deirdre, can you just hold a wee second? Because Ciara wants to come in Ciara wants to come in that specific point.
Yeah.
Yeah,
If
no
that's all
problem.
right with you, go ahead, Ciara.
Just on that specific point, Lisa, has this ever been flagged up before with the PSNI? Because in the general fashion, through all my lifetime, for those that have had to go back to the PSNI for whatever, they're given a period of time and then they go in because the PSNI station is open 24 hours a day and most people, whether they're working or whatever. So it's worked, in my opinion, really well for the general public. So what I'm asking is, there's been any research previously done, or has this been highlighted by the PSNI consistently over a long period of time? Is there any evidence for that, or has this just come about as a result of the consultation now with yourselves and the PSNI?
We've been looking at it in terms of the powers about the powers to take fingerprints and DNA. So we've been looking at it solely in that context, and it's come about as a result of experience in England and Wales that led to legislative amendments being made there, and that's the experience that we've learned from there in making this amendment.
But obviously England, Wales is totally different environment to here in the north, so I wouldn't take that as read. So at this moment in time, there is no other localised research done on this.
Well, in terms of the biometrics, these recall powers haven't been used before. They're new powers that will be coming in, so we don't have any experience of these particular powers working to date.
No, I'm not talking about the actual legislation point. It's about going to the police station and that date and time and a specific appointment being made. That's that aspect, which has always been the case, but it's never been flagged. So generally there's been no research and it's never been flagged before as an issue, but based now on this forthcoming legislation, it has been flagged.
Based on the experience of taking fingerprints and DNA, because of the processes that have to be gone through, I imagine.
Okay, no, thank you.
I wonder, is that on the basis that is it only certain police officers or nurses or whoever who take the DNA from a person?
And certain police stations are only open certain hours, and certain police stations are closed to the public. So there's designated stations.
Yeah,
I
there
think
has to be done in
where
the custody suite, and particular equipment has to be used, and the sample bags and all that sort of material ready to be used for processing the samples appropriately.
Yeah, so it's probably just to make sure that there's actually people there to do it. I mean, I presume it's the same issue as with us getting our pictures taken here for security passes and so on. They're not always here when we're here. So, yeah, it's an interesting one, that certainly about the arrangements. You know, if as Deirdre says, if people are going to be afforded some degree of flexibility, for a mutually agreeable time, yeah, that's fair enough. Okay, Deirdre, you had a final point you wanted to make?
Yeah, the last wee one was just around, again, it's retention and the use of the data and stuff as well, particularly pertaining to young people, because I know it's something the Children's Commissioner has raised, and indeed the Human Rights Commission as well, around the stigmatisation and also innocent until proven guilty, and looking at some of those retention periods for young people, and particularly around the Marper judgment as well. So it's just, what has the engagement and the stress testing been around that? And is that part of that other piece of work say that you mentioned that the ESO are doing in terms of looking at the human rights compatibility, but particularly through the impact on young people, I would be worried about.
We've had some engagement with the Children's Commissioner and with the Human Rights Commission. It's something that we know that they have particular views around the retention periods included in the legislation, and we've tried to explain the rationale and the particular provisions and provisions that we have made for children and young people, where there are shorter retention periods and where there are, for example, exemptions for first minor offences for under 18. So we've tried to explain the differences that we have made for children and young people in the legislation, and we're also continuing to engage with the Human Rights Commission and the Children's Commissioner as we work through the detail of our review mechanism, which will be an important safeguard to make sure that material isn't held for any longer than necessary. So we're still, we're at the early stages of doing work on the review process, and we'll be continuing to engage with the Children's Commissioner and the Human Rights Commission on that.
Okay, Deirdre, are you following up?
Thank
or?
you. No, thank you. I'll let somebody else in that. Sure.
Thank you. Connie?
Thanks, Chair, and thank you for coming in today. To be honest, my question was really about the PSNI involvement with the drafting of these amendments and the input they have, but I mean, I think that's been fairly covered in the questions Deirdre's asked, unless there's anything else. And I think from my own knowledge, a bit more information about what the stress testing actually involves and the information that you received that, was the rationale for some of these things. For example, the grace period for holding fingerprints on the individuals under investigation from 14 to 28 days is obviously, there's quite a difference there, and just a bit more information if you were able to provide it on the rationale and the feedback you received for that.
Yeah, I suppose it's kind of been a two-way iterative thing, as we've worked quite closely with our colleagues in PSNI who lead on biometrics. So it's kind of been, as we've been drafting instructions or dealing with queries from Legislative Council or thinking through how policy would be intended to work, we've been thinking of questions that occur to us about, how does this work in practice? What would this mean? How would this work for you? Or going to them to think about, well, in what sort of scenarios could arise here? What sort of, give us examples of something where this might be needed, or they've come to us proactively with something saying, well, if we have this could be the result, or if this situation arose, we would need a power to do X, Y, and Z. So it's kind of been that kind of two-way exchange on various things, and obviously we've been sharing drafts with them to let them see what the legislation's looking like and how that might work in practice. For the increasing the 14 to 28 days, I think that was kind of something that we kind of looked at ourselves and discussed with PSNI and took account of their feedback. But it was to make sure that if we're putting timeframes in the legislation for deletion, that they're clear, so that the PSNI have a bit of legal clarity on what their timeframes are, and to make sure that they are reasonable and that they are workable in practice, and that do allow the time for the outcome of an investigation or court proceedings to be determined, to be finalised, to be communicated, and for systems to be updated, allowing for glitches that maybe delay something happening, and then allow, if a case comes to, proceedings come to a conclusion and there's no conviction, but the police then want to make an application to hold the materials to continue to hold the materials of the Commissioner, allowing time for that to happen. So it's just been as we've kind of thought through how things would work in practice.
Thank you, Chair. Just another quick one.
Go ahead, Connie.
I don't want to ask you to obviously speak on behalf of another organisation, but it does sound like there has been, a good amount of collaboration. And would you say, from your perspective, you're content the PSNI are happy with the amendments and the proposals you brought forward under the biometrics section?
I wouldn't want to speak for them, but I know, and we obviously haven't been speaking to the entire organisation. We've been working quite closely with the people on biometrics, but I think, we've worked on it with them, and I would hope that they would be as content as they could be with what we've got, but I wouldn't want to speak for them. We've tried to get this stuff to get agreement with them on what we've put through, and how it can work in practice, and to reflect all the issues that to take account of all the issues that they've raised with this, and hopefully we have been able to do that. But I wouldn't want to speak for them on that.
No problem.
But I would hope so.
The intention is obviously that when it comes to implementation, we're implementing provisions that have the support of operational partners. Something similar happened with the stalking legislation from the last mandate, where the preparation of drafting instructions was heavily involved input from operational partners in the courts, the police and PPS. So that was, as Lisa said about the biometrics, it's an iterative process. So it's not that a document is produced and the police get an opportunity to consider it once and that's it. You know, it's very much an ongoing process throughout the entire drafting of provisions, and even at the point where final drafts are produced, those are shared with the police and operational partners, with the intention that once the legislation receives its scrutiny and if they are successfully passed by the Assembly, implementation is a straightforward matter on the basis of what the police and other agencies are expecting the legislation to be, rather than there being significant or widespread changes between the initial policy proposal and the legislation being drafted and then coming into force, and it presents them with perhaps difficulties that they may be insurmountable in terms of the legislation if it's so different from what was initially proposed. So I don't think there's any part of the department that doesn't work extremely closely and hand with the police whenever it comes to measures like this.
Thank you. Thanks, Chair.
Connie?
Yeah.
Doug?
Yeah, thanks, Chair. Can I just very briefly just ask, was the ICRIR involved in any of the stress testing? And do you have any concerns with the government's sort of repeal and replace of the Legacy Act, whether it will be a known unknown or an unknown unknown for things that will happen in the future in regards to biometrics over the next 12 months?
No, we haven't been doing any stress testing with the ICRIR. ICRIR isn't really within our remit. Our remit has been focused around PSNI, and obviously the ICRIR and Legacy is responsibility for NIO, and the Minister's made her position on the Legacy Act quite clear. In terms of biometrics, the NIO has made provision for protected material for use by the ICRIR, and I think those discussions around how all that's going to work in practice will be a matter for NIO, ICRIR, and police and other operational partners.
Okay, and I guess that's a fair enough answer. But you can see the point that I'm making here. I mean, if we're not involved in the ICRIR even to get information, if they get to retain information from 1975 in regards to a legacy case, and yet we are destroying evidence from 1975 for a rape case, for example, you can see where you could see that some people might be slightly concerned that there's one rule for one and one rule for another, and that's kind of where I'm seeing. I mean, there is a crossover here, whether we like it or not.
Yeah, I appreciate that there's obviously an interface and there's a difference in approach, and I think the difference in approach is a result of the UK government putting in place the legislation to protect material for legacy investigations. We are putting in place legislation to address the Marper and the Cochrane judgments. It will mean that if anybody's not convicted, their material will have to be deleted. If somebody's under investigation, their material can be held while they're under investigation, or if somebody's convicted, their material will be retained for the retention period is relevant to their conviction and the nature of their disposal. The difference in approach between historic cases, between legacy cases and other historical cases, is a result of the UK government legislation and the Legacy Act.
It is. You're right. But it still affects the Department of Justice. But listen, I'll leave it there. Thank you for your answer.
No, Doug, I'm kind of grateful that you went down that road, because it was my intention to go down that road too. Appreciate it's a while since we've had you in front of us with regard to the bill, and I'm still wrestling around the whole 3 year, the figure of 3 years, in the context of Legacy 2, because as we all know, not everybody who has been involved has been investigated or convicted, and I worry about the impact of that kind of going forward, but I'm also trying to balance that from the human rights perspective of, well, if there's nothing on anybody's radar, why on earth would your DNA be held? So I'm just trying to work through that myself. Could you remind me of how you came to the 3 year?
So the 3 year is a specific provision, and it relates to whenever somebody has been charged or not convicted, or convicted not charged, and there's certain circumstances and certain criteria that have to be met for it to be able the police to hold that material for 3 years. That was a provision that was already previously included in the Criminal Justice Act in 2013 and reflects similar provision that was made in England and Wales. And I think it was because that was a very particular circumstance where there was a charge but not a conviction. I don't think anybody wanted to put it in place on an unreasonably long period of time. They wanted to keep, because it was a very sensitive and very particular provision for particular circumstances, it was a short retention period. There is a provision to seek a further extension to that through the courts. So that's one particular provision. If somebody is under investigation for an offence, the material can be held until the investigation is completed or until criminal proceedings are completed, and then that would depend on whether the person was convicted or not, whether it then had to be deleted or could be retained.
Can I check with you just in terms of a general point? Does this only apply where the DNA is assigned to a specific person? So what I'm thinking about is, for example, take a look at some of the US cases, with some of those serial killers and rapists from the 70s, who the police had their DNA but didn't know who it was, and only now, it was the Golden State Killer, I think, only now have they been able to link the DNA to a person. So presumably, can the police hold DNA from a crime scene for more than 3 years if they do not know to whom it belongs? Is the issue purely if they take your DNA or my DNA and they know that it's ours?
I think crime scene material would be held as part of the case file, and that would continue to be held while the case file would still be open. So it would be the profiles would be held on the case file, and that would be different from an individual sample. So then, if they searched that, if they took the material, if they go back to that case file and took the sample from the crime scene or whatever and run it against the database years later and then got a hit from somebody, that would still...
That's still fine. Can I just check then, in terms of the legacy issues, you've been very clear about what your aims are in this and you're aligning with court judgments, but are there going to be any impacts from any of this and from the review, the government's now review of its legacy act? Do you anticipate changes? Do you anticipate impact?
At this stage, we don't anticipate there needing to be any changes to our legislation to address legacy issues. Our legislation deals with material taken under another legislation. The UK government has put in place measures to protect material for use by the ICRIR. No. I don't think we envisage at this stage any changes to the biometrics provisions within the Legacy Act, but that's something that we continue to liaise with them on. But we don't anticipate that there will be any changes needed to our legislation as a result of that.
Great, thank you. And right, before we move on from biometrics, does anybody have anything else they want to pursue with regard to biometrics, or are we content to move on? Ciara?
Just one, and it's perked up my curiosity regarding the use of the biometric data and the DNA, because I'm quite conscious, obviously, in relation to the use of it by the PSNI. I can understand an individual's DNA profile, but say I was on the system and it flagged up that I was a second or third line descendant of the person that you're looking for. It's the use of it. How is it used by all?
Genealogical
The
DNA.
genealogical side of it, has that been incorporated into this?
I think forgive me, I'm not familiar with the detail. It's something that we can come back to if necessary, but I know that there is guidance in place around familial searching and how all that's managed through the database. I'm just not familiar with the granular detail of it, but I know that I think there's guidance in place around familial linking and how that's used.
That may be a question we can put to the PSNI.
I think
at the
so,
point
yeah,
at
they
which
would have the detail on that.
It would be useful to be aware of.
Yeah, because I'm aware that they do use that.
But it's for individuals themselves with biometrics, because this will be, I think, intended by a lot of people from the general public, so it will spark up conversations like this as to what is being collected, but then how it's been utilised and the implications of that.
I think where it's been used in the USA, it has been from, the way that a lot of these people can connect you with your relatives.
Yeah.
So you're voluntarily submitting your DNA, and that's how they have established the links. But it's a question we can put to the PSNI, and we'll take a note of that. Does anybody have anything else? Is there anything else you guys want to say about this, or are you content to move on?
I was just going to ask, Chair, on behalf of colleagues, if you're finished with the biometric material and as we move through the other policy areas, if you're content for those officials to excuse themselves, or if you would like to have them remain at the table for any follow-ups that might occur.
I'll leave that to members. Do you anticipate that you might end up coming back to anything within biometrics, or are you content for people to head out?
I'm
Content
content.
for them to go. I think any follow-up maybe after this committee anyway. So, and if we can just get the written updates just to the queries, that would be good as well.
Yeah, I think, Andrew, certainly in terms of all of this, I don't imagine this is the last conversation we'll have, and presumably then
Not
as
at all.
things arise, we can be in touch with you. We could ask you to come back in and so on. So Lisa, thanks very much. That's great. Just before you leave though, can I check with the team? Do we as a committee have all we need covered? And that I just want to make sure that if there are gaps, we've got it covered. Yeah, all good?
Yep.
Yes. Right, Lisa, thank you very much.
Really thanks.
Right, where are we now? What's the next thing? Restorative justice. Who's up for that?
Restorative justice is my good colleague Veronica. Veronica is the head of Rehabilitation and Reducing Offending Division in Prison Service. And rather than attempt to rehearse the nature of your provisions, I'll let you speak for yourself, Veronica.
Thanks, Andy. I'm happy to give a very short, brief overview in terms of kind of the rationale and nature of the provision. So I suppose there's two elements really associated with the provisions that have been brought forward. One is to deal with an oversight in terms of the transfer of provisions on the transfer of devolution for placing security justice type provisions at the time that was devolved. So it's really in terms of the powers associated with this currently in relation to accreditation of organisations sits with the Secretary of State. There's an agency agreement in place in relation to that, but I suppose one of the elements of the provisions is really to try and address that aspect. The other aspect is really, I suppose, reflecting the fact that there's been a range of work in progress taken forward in relation to this area of work over recent years, and I suppose it's really to try and put on the statute books what the nature of that is and some of the requirements that are going to be put in place in relation to that. So in terms of restorative justice more generally, there previously was a 2007 protocol. There was a review undertaken of that. It was revised and then a new protocol published in 2023. Associated with that piece of work, we're looking at and keen to expand the number of organisations and individuals that are involved in this sphere. So the new provisions, I suppose, are really setting out what that new framework will look like. As I say, we're keen to expand the number of individuals that may be involved, but also what we want to do is to make sure that there's a robust framework in place. So we'll be introducing new practice standards and an accreditation framework associated with individuals that are taking part in restorative justice as part of the criminal justice process. So the legislative provisions are really setting out what the requirements are in relation to that, will enable us then to set those robust standards in terms of individuals that are going to be involved, and I suppose ultimately ensuring that anyone working in this field, that we're satisfied that they have the necessary skills, experience, expertise and can evidence that, and that there is a consistency of standards across the board in relation to this area of work. So in a nutshell, that's probably really kind of the two aspects related to the provisions that are being brought forward.
That's helpful, Veronica, and certainly means some of our issues have been around consistency and safeguarding and the processes. Certainly Deirdre and I have been on, we've got similar lines of questioning, so I'll let her go first, and then if I have anything else I want to pick up on, I'll do that. But go ahead, Deirdre.
Yeah, no, and thanks very much, Veronica, as well. I suppose it is on that issue of the accreditation in terms of broadening it out and looking at statutory and non-statutory organisations. So it's just what thoughts or plans are the department putting in place in terms of safeguards, ensuring there's a consistency of service provision as well, and the role of CGINI in terms of oversight around all of that. I suppose that's my first question. My other is to make sure then as you do broaden it, because this is an important area of work, and as was reflected by the Victims of Crime Commissioner, that you want to encourage restorative practice more in terms of that access to justice as well, but making sure that the service isn't just monetized or commercialized in a way, the way I suppose mediation or restorative justice issues in America have taken off, that it's really those who can afford So it's just looking at that whole area of work, and then just what engagement then you've had with Criminal Justice Inspectorate in terms of some of the proposed changes, and also from those who are accredited at the moment. Have you been engaging in them on their views in terms of how things could be improved around this area of work as well? Thanks.
Okay. I'll go through each of those points in turn. So I suppose in terms of kind of that oversight, standardisation, the assurances in terms of kind of the standards that are going to be in place, I think really that's a key element of the work that we're currently taking forward to ensure that basically the processes and systems that are being used here are as robust as possible. So the accreditation, the practice standards and the accreditation framework will set out very clearly the practice, the experience, the training, the skills, evidencing of that in relation to any of these practitioners that are going to be working in this field. So the focus in terms of the changes has been very much to try and make this process and the way in which the system operates and the assurances that we have around the robustness of those individuals and the process more generally, to make that as comprehensive and robust as we can. There would have been discussions with Jenny earlier on in the process in relation to kind of their role as part of this process. And I think there was very much a focus, or it was felt that there is a material role for Jenny in terms of inspection once this process is up and running, once the scheme is operational, and ensuring that there is, I suppose, something material for Jenny to look at and to be reviewing. So Jenny will continue to have a role in terms of the ability to undertake inspections in relation to the organisations and individuals that are undertaking restorative justice as part of their range of work more generally. In terms of the second aspect, so I suppose really in relation to kind of reflecting that the purpose of this is to try and very much encourage access to justice, to enable individuals to be able to avail of a restorative justice process, and concerns around, I suppose, that monetisation or commercialisation of this process. The focus of this, and again, as I suppose I'd noted at the start, the focus is very much about trying to ensure that it's the highest standards that are being applied, that there are assurances in relation to that. And I suppose for us, that is very much what is driving the change, as opposed to, I suppose, a commercialisation or making of money in relation to this process. More generally. And then I suppose in terms of the aspect around the engagement that there's been with the likes of Criminal Justice Inspectorate as well as the accredited organisations, more generally, that has been part and parcel of our process as we've gone forward in relation to this. So as I say, there would have been engagement with Jenny ahead of these changes being brought forward. We also have a restorative justice working group, and the organisations that are currently accredited as part of that process sit on that group. They, along with a number of other voluntary and statutory sector partners, have been fundamental in terms of the revision of this process, the introduction of those new practice standards and the accreditation framework. So they have seen the draft documentation processes, the standards that will be required in relation to this, and what that new process is going to look like. And the organisations that are currently accredited, as well as other partners that may be involved in this process going forward, there has been a very positive response in terms of that engagement with them, the process that's being introduced, and I suppose what ultimately that we're trying to the standards that we're trying to assure in relation to this. So there has been and will continue to be engagement with those organisations, and the response to date has been positive. We've had very productive conversations with them in terms of the practice standards and accreditation framework document, and getting their input in relation to that. Hopefully, Deirdre, that answers your 3 points, but if there's anything that I haven't covered, please do let me know.
No, that's great for now. Thank you.
Thank you.
Morris?
Thank you, Chair. Just a couple of points picked up during the discussion there, and that would be the effectiveness of any new accreditation process and the criteria used for that. I mean, to hear that some of the people that are delivering this restorative justice are actually on the planning of it is a bit like the police investigating themselves. You know, there needs to be more checks and balances. And the long-term evaluation and future-proofing of these changes needs to be considered as well. I'm just a wee bit worried about the effectiveness that any new accreditation process and the criteria used around it does not have the pre-accreditation inspection and impact that already exists from SEGINI. So I was wondering how you're going to address that. I mean, it seems to me that you're broadening up the avenues. You're bringing more people in from whatever background. It's irrelevant. They will be practitioners, but there doesn't seem to be any new checks and balances that you're bringing the right people, the right organisations on board.
Thanks, Morris. I'll try and address those points as best as I can. I suppose in terms of that first point in relation to accredited organisations being part of the process, I think what we felt, it is a multi-agency restorative justice working group that we have, so there's a range of organisations involved in that. The other point that I would make, and I should have probably covered in my address because it hopefully would have been helpful, is that as part of this process, the revision of the protocol, etc., there has been the introduction of an independent protocol lead who is driving forward this work. They have around 15 to 20 years experience in this area, are very, very experienced. And I suppose it's, there is that element in terms of them ensuring that this process is as robust as we possibly can have it. As I say, we have had conversations and discussions with SEGINI in relation to the changes that are being brought forward, and SEGINI will continue to be a fundamental aspect in terms of this process more generally, in relation to retaining their ability to undertake inspections in relation to this when the scheme, the revised process is up and running and operational. So there have been ongoing discussions with them in relation to those changes being brought forward. In terms of the long-term evaluation and I suppose ensuring that there is that kind of future proofing of the process, the changes are very much intended to try and ensure that we have a system in place that is as robust as possible. As part of the process being introduced, there will be a time frame associated with the accreditation for organisations, so there will be a re-accreditation process associated with that. Again, the interim protocol lead will be fundamental both to decisions that are being taken in relation to the accreditation of organisations. At the end of the accreditation period, which we envisage is a 3-year period, as part of that process, they will review and look at and get annual information provided from organisations that are providing services to ensure that we as a department can be assured and that they as the independent lead in this area have assurance as to the quality of work that's being undertaken and that there is sufficient evidence in terms of the quality of service that is being provided. Hopefully that addresses your questions, but again, if there's something that you feel I haven't covered, more than happy to address that.
No, just to pick up through you, Chair, one that Deirdre raised there, and that's the monetisation of the process. I think there needs to be robust checks that the process just doesn't become an avenue for drawing down funding that actually does deliver what it says in the tin. And the monetisation, I think, needs to be really tightened up.
And that's something that obviously, will be fundamental as part of the work that we're taking forward and through that independent protocol lead. Our focus is very much on ensuring that there is quality service provision provided, that we have the necessary checks and balances and assurance in terms of the quality of service that is being provided to individuals. And as part of the process, and I suppose that kind of wider review that would be associated with any measures being brought forward, what will be fundamental to that is that we have information feeding into the processes in relation to the quality of service provision, what the views are of those that are engaging in the process, and that is feeding into kind of, I suppose, a review or outcomes-based process. So again, that we can have assurance as a department that the service that is being provided is effective for those individuals that are going through the process and that they feel it is making a positive difference for them. The focus is very much about ensuring that we're reducing and trying to address the harm that has been caused for all parties that are involved as part of that criminal justice process, and that will continue to be a key driver for us going forward.
Okay, thank you, Chair.
Thanks, Morris. Doug?
Thank you, Chair. Look, I mean, I'm pretty comfortable with this, to be perfectly honest with you, but I think Deirdre and Morris have raised pretty valid points. I mean, if we're talking about growing the restorative justice sector, that as it stands now, I'm trying to get a sense of what we're talking about growing it, doubling it, trebling it. What is that going to be? And as it grows, then it will dilute the oversight unless there's a resource set aside to make sure the oversight of this sector as it grows is in place. Could you give us an idea of how you see it growing? To what size do you think it'll expand, and where that extra oversight is going to come from a department which is squeezed of money?
Thanks, Doug. I suppose in terms of the current position, there are 2 accredited organisations. So it's Northern Ireland Alternatives and Community Restorative Justice Northern Ireland. Community Restorative Justice Ireland. I think our sense at this stage is that there are going to be a number of other voluntary and community sector providers that will be interested in getting engaged in this. Likely a number of kind of the key organisations that are working in this field at the moment. I suppose the extent of the expansion is also going to be very much dependent on the amount of monies that may be available to provide funding in relation to this, and I think also the extent to which this process is adopted and used by those that are going through the criminal justice process. What we would intend to do is use a phased approach in relation to this. In the first instance, we're looking at an expansion into diversionary type disposals. So those cases that may enable, that are kind of, I suppose, on the cusp of the criminal justice process. We'll do this over kind of a phased approach, so that we're very keen, I suppose, something that we emphasise in terms of the engagement with our restorative justice working group. Very keen to have this system embedded in and the process working. So doing kind of a phased approach to that and ensuring that it works well before we do further expansions and rollouts of this.
And I guess, a robust registering of individuals who are going into the sector is really important, and with that then comes a robust being able to deregister individuals. And I see certainly in your amendments that you have that down, but again, it comes back to making sure you can find the problem before it infects the whole system and that resource. So I take it there is a robust registering, and how does deregistering somebody actually work if you feel that they're not up to speed with what they should be doing?
In terms of that oversight role, again, the independent protocol lead is going to be critical to that in terms of that process. In terms of the framework that's being introduced in the practice standards, there is going to be a very robust process in terms of what the requirements are for those individuals. Those will be clearly set out in terms of both their experience, their skills, their training, the evidence of that as part of the process. Obviously, there is that reaccreditation process whereby individuals will have their accreditation for a time-limited period, and that process will have to be gone through again with the same assurances. Equally, should something arise during the course of an accreditation process, the independent protocol lead will have the ability to look at that and consider whether or not that accreditation should continue. So, we would be of the view through the enhanced practice standards and the accreditation framework, along with the role of the independent protocol lead, that there are robust safeguards and checks there in terms of how this process will operate.
Thank you, Chair.
Thanks, Doug. I've got a few bits and pieces. Veronica, could I just follow on immediately from what has been discussed? You had mentioned there about, Doug had spoken about resources, and you'd said obviously you'll work through and people will apply and all the rest of it. So what I'm trying to establish is that going to be done by kind of criteria and scoring? Or is it going to end up first come, first served, and then when the budget's done, nobody else is going to be accredited? Just what are your thoughts on that?
Yeah, and I suppose it might be helpful to set out that there are probably, I suppose, 2 elements in relation to that. There's the accreditation, and then there's the resources that may be available for work to be undertaken. And I suppose a key thing at present, and I would imagine will continue in the new process going forward, is that it's a relatively small pot of money that comes from the department to those 2 organisations that are currently accredited. Mm-hmm. That accreditation in and of itself is important for them in terms of tapping into and accessing other funding. So in terms of the department's monies that we provide, is between 100 and 150,000. Those organisations then have access to a significant amount of money from other areas across government, such as the Executive Office, Department for Communities, etc., have contracts in the region of over £1 million for some of them, you know, so there's that kind of restorative practice piece, and then the restorative justice element. And restorative practice is where you're applying those practices, but it's not necessarily linked into the criminal justice sphere as such. You know, so there is an element of accreditation in and of itself isn't necessarily strictly or limited to that criminal justice work being undertaken. It is also providing an assurance, I suppose, in terms of other departments and bodies undertaking work outside the criminal justice system. So I suppose what I would say is that we would almost view it as the accreditation and the funding of criminal justice work are almost two separate but very intertwined from a justice perspective piece of that jigsaw.
Which leads me into another question that I hadn't anticipated asking. But do you envisage these practitioners engaging in preventative work? Now let me explain why I'm asking. At present, there is a limited pool of funding, and those who engage in local work are now finding themselves kind of competing with people who traditionally wouldn't have been in their sector or in their lane, if you want. So, you know, as people involved in restorative practice or restorative justice measures kind of broaden their lanes, if they're going into the preventative arena, then that impinges on funding for other bodies, and they're now in competition with people that they hadn't been previously. Is that what you envisage? Do you envisage them going into the preventative space?
And I suppose, it's probably that kind of distinction between restorative practice and restorative justice. So we would reference, albeit the kind of the underpinning principles in terms of bringing individuals together, trying to resolve issues, reduce harm, you know, get, I suppose, answers for some individuals. We would view that very much as there is the work that's being undertaken in relation to the criminal justice system, that reference to restorative justice. A range of these organisations are also involved in restorative practice, so similar principles are being applied, but very much in other spheres. So you will have this applied in, for example, in schools, in community settings. So there's a range of work that's undertaken by a number of these organisations in communities, in education, those other departments. And I suppose, again, coming back to that point, if you were to look at, I suppose, the funding that a number of these the currently accredited organisations, plus I would imagine in the new world going forward, for want of a better phrase, the Department of Justice funding in relation to that is an incredibly small amount. You know, it is really that kind of wider piece and that wider restorative practice where a lot of their monies would come from. But yes, there are, you know, inevitably going to be a wider number of organisations involved, and I suppose for us, it's to try and kind of spread that practice and good standards across Northern Ireland, because at the moment the accredited organisations aren't necessarily spread across Northern Ireland, so that would equally be part of our aim to try and ensure that service provision is spread across the locality, as well as ensuring that the standards that are being adhered to are as high as possible.
Thank you. Martha, can I go back to a few basics on things, just for my own kind of understanding and moving this forward? Because in terms of the accreditation process itself, I don't know if everybody in the room is familiar with how it already works, but some may not be, and I think it might be useful, perhaps not now, maybe through a written paper, if we could have kind of
about what the current process
yes.
is and what the new one.
Yes,
we can...
what it is now, what it is, and also in terms of the registering. You know, should that, because I suppose my questions around that aspect, to follow on from Doug, are okay. Well, what is the process to remove a person or an organisation? Ultimately, do the criteria for each aspect that are applicable to an organisation, are they equally applicable to an individual, or are they different? What are the criteria? What's the appeal mechanism? You know, some understanding of that would be helpful for us, I think, just to understand the whole process and to see what you're trying to do here.
Yeah.
That would be useful. Morris had raised the issue of building in a review process after a few years. Look, with regard to restorative justice, I think it can be a great thing. In the wrong hands, not so much. And I think, bearing in mind everything that people in Northern Ireland have been through, I think that they'll be seeking reassurance and to be able to be confident in the fact that those who engage in restorative justice by day are not engaged otherwise and in other activities. And I think that's a big thing for people in Northern Ireland, actually. So can you give us some reassurances around this process and the changes, and particularly when you're removing Sagini at the start? I'd like some reassurances around that and around the accreditation process to ensure that individuals or organisations are rooted out and kept far away from positions where people and their families are vulnerable. That's the first thing.
No, I'm more than happy to run that through with you, and fully appreciate the concerns that you or others may have in relation to that. I think from a departmental perspective, we would be very much of the view that the process that is being brought forward is much more robust, has a high, there is a high standard of requirements in terms of the individuals that are going to be coming through that process. There will be 3 tiers to the accreditation framework, with the highest level relating to those criminal justice cases which are dealing with serious and complex matters. And for each of those tiers, it will be quite clearly set out what the expectation and the requirements are in terms of, I suppose, the what they have to demonstrate in relation to that. So that will relate to the length of time that they've been working in this field, the level of experience that they have, what that experience has involved. It will also set out that there has to be certain levels of training and continuous professional development undertaken. So, as I say, there kind of be 3 tiers in terms of the level of experience, skills, training, etc. that individuals will have to demonstrate as part of this process. So certainly we are satisfied that there is a robust process there in terms of what has to be shown and the skills that those individuals have to demonstrate, particularly given the vulnerabilities of the individuals that are going to be involved in this process, both by way of victims of crime and also those that may have caused the harm to those individuals. So I certainly think in terms of that process, and it is something that we will can share with the committee in due process is the documentation. It's obviously going to be made available online as well. It is comprehensive, setting out kind of what this entails, what the requirements are, what people have to do, what has to be undertaken in order to be able to deliver services in this field. And a fundamental of that is obviously adhering to the rule of law. That is a key part of the process, so that, as you say, you don't have individuals that are doing one thing by day and another by night. That there is a robust process in there in relation to that. We will also have as well as the independent protocol lead having a key role in terms of that accreditation process, re-accreditation process, and if any decisions were taken in relation to an individual being deregistered, we will also want to have a panel which will essentially look at those cases and confirm that they are content with the position that the independent protocol lead is taking in relation to that. And then there will be, as the final part of the process, a sign off by the Minister in relation to that case. As I'd indicated, obviously it's intended that the accreditation would last for a 3-year period. There would have to be a further accreditation which isn't in place at the moment. So essentially at the moment, I think the last accreditation was undertaken in 2010. There isn't a re-accreditation process associated with that, albeit that individuals may drop out of the field. So the intention is that we would have a 3-year kind of period, and once that is coming to a conclusion, people will have to go through that process again and have demonstrated the work and level of expertise and experience that they have been undertaken, and the quality of the work that's been undertaken as part of that process. And as I said, the independent protocol lead will have a key role in relation to that. Were something to come to light that would raise concerns during that process, there is that ability then to look at that continued accreditation of that organisations. It's not that we'd have to wait to the end of that 3-year period. And as I say, the independent protocol lead is going to be a key element of that process more generally.
So just to firm it up, the accreditation process itself will take 3 years. At the point at which somebody is accredited, for how long are they accredited before they need to renew?
So essentially, the 3 years is from the point they're accredited. So if they're given
3 years to do it
accreditation,
and then another 3
yeah.
years.
So if you're accredited in 2025, you'll be reaccredited in 2028. In addition to that, there will be that ongoing review and monitoring by the independent protocol lead of the work that they're undertaking. They will have to submit reports to the department in order that we can see the number of cases that they're involved in, the type of cases, and as I say, as part and parcel of that process, we will want to get information and feedback from those that are involved in and receiving those services to ensure that they are satisfied and that they feel that those services are making a difference. So there will be kind of that ongoing evaluation is probably too strong a word, but that ongoing kind of review and monitoring process. It won't just be a case that individuals would be accredited and there would be no oversight or engagement with them until the end of that 3-year period. That will be very much an ongoing oversight and monitoring role in terms of the work that they're undertaking.
So in terms of the inspection, you've moved from a position where Jenny goes in advance of accreditation and you're moving to them going in after accreditation. Could you maybe outline your rationale for that and why it wouldn't be helpful to have them maybe doing both? And also with regard to re-inspection, the paper talks about they'll be inspected from time to time. What do you envisage by from time to time, and what is the re-inspection period currently?
In terms of that first element in relation to Jenny, as I've outlined, and you'll see from the provisions, the decision is that they will continue to have that role once an organisation has been accredited and is undertaking work in this sphere. There were a range of discussions with Jenny ahead of those changes being brought forward, and certainly my understanding is that in terms of that engagement, there was a sense that I think Jenny, in terms of their oversight, inspection, monitoring, there was a sense that it was much better to have that involvement when there was something material to look at in terms of the work that was being undertaken, combined with the fact that we're having a much more robust process ahead of organisations being introduced and given that accreditation. So there were those ongoing discussions with Jenny in relation to their role as part of this process more generally. In terms of the inspections from Jenny, it's not that there would be anything set out in stone, but Jenny could, as part of their programme of work more generally and under the powers that they have, could decide to undertake inspections in relation to this sphere to look at, and I would envisage in all likelihood will do that as part of the new process being brought forward. We'll consider that at a point in time, can undertake an inspection to see how that's operating and ultimately, I suppose, make recommendations back to the department in relation to that. So they have been there have been discussions with Jenny in terms of that change being brought forward. So as I say, there's nothing kind of set in stone or concrete in terms of the inspections, and that from time to time, I suppose, is really just to give that flexibility that they could, when they should decide it appropriate or necessary, could undertake an inspection in relation to this area of work.
Thank you, Veronica. So just to finalise then, you're going to write to us to outline how essentially the process will change, how you envisage it changing, what the 3 tiers are, what the criteria is, and the process to remove, and any appeal mechanism there may be. Also how you will ensure consistency between individuals, organisations and across Northern Ireland. Is that fair enough?
If that's helpful, we're more than happy to provide the committee with detail in relation to that, and can provide, as I say, the practice standards and accreditation framework has been drafted. It's went through review with a range of organisations, and we're in the process of finalising that at the moment. But we can certainly set out kind of a synopsis, probably covering 2-3 pages of what, the key elements of that and what that looks like. More than happy once we provide that paper. Obviously, if there are any further queries or information that committee members want in relation to that, we can come back on that. But yes, more than happy to do an overview paper in relation to that.
That's really helpful. Thank you very much. Okay, so does anybody else have anything else on restorative justice? Do you guys as a team have all that you need?
Mm-hmm. Yeah.
Yes, all fine. Is there anything else that you folks want to add before we close this section off? No? Right.
Wouldn't attempt to add anything to what Veronica's offered. Again, it's an area that, about Veronica's knowledge on it, there's a great deal of detail there that she's she's explained very well.
No, that's really helpful, and then we'll hear from you then as we move forward. Veronica, thank you very much. That's great.
Thank you for your time, much appreciated.
Our members' content then, I had originally said about moving to Access NI, but we may move to serious organised crime, because I think there's stuff in relation to that may impact Access NI. Our members' content to move to serious organised crime then? Yeah, just in the order of our papers. So who's up for that, Andrew?
Katie Taylor, who's the Deputy Director, Head of Protection and Organised Crime Division. And again, this is an area that I have only a very superficial knowledge of, so I'll spare my blushes and not attempt to talk about something that I really know very little about. So over to you, Katie.
Yeah, thank you, Andy, and thank you, Chair, and the committee for the opportunity to discuss the proposed new organised crime offences. So I'll just give a very brief introduction. I don't want to repeat what's in your briefing paper, but I think we can all agree that organised crime groups cause extensive harm and exploit vulnerable people within our communities to further their own criminal ends. Northern Ireland is currently the only area within the UK or Ireland without bespoke organised crime legislations. So these provisions, the introduction of these provisions, if they're brought through, will bring us in line with neighbouring jurisdictions. As you know, the main purpose of the new legislation is to create two new offences. So participating in the criminal activities of an organised crime group and directing the criminal activities of an organised crime group. I should say from the outset that it's important to recognise that we don't anticipate that the directing offence will be used frequently, but we think that, and operational partners agree, that it's an important tool to have in the toolbox for when it can be used. Members will also wish to note that under current practice, those who direct and participate in the activities of organised crime in Northern Ireland would be routinely charged, and if the test for prosecution is met, prosecuted for offences related to the crime type that they're suspected of being involved in. So, for example, drug trafficking, money laundering, fraud, firearms, human trafficking, whatever that offence might be. So whilst these offences can obviously still be utilised against these individuals to deal with the immediate law breaking, they don't take into account the organised crime element of the offending. The introduction of the new offences, therefore, and the associated penalties, we think will more accurately reflect the serious nature of this type of criminal activity, therefore acting as a deterrent. It also sends a strong message that there are no individuals that are deemed to be untouchable from their criminality. Over the last year or so in finalising these provisions, we've carried out significant engagement with operational partners. We want to ensure that the new provisions provide a more flexible and also a future-proofed approach for law enforcement to capture involvement at all levels of organised crime. And I'm happy to take any questions you might have on the draft clauses.
Thank you, Kate. Doug has got stuff around the directing offence.
Yeah.
Sorry, Chair. Thank you. Look, it's a very general point I wanted to ask, because I'm in favour of a new law against directing organised crime, but I'm trying to figure out how that's different between directing terrorism, and how it all knits together within an action plan on paramilitarism, criminality, and organised crime. Is there a repetition in any of these, or can they be all brought together and used as one offence?
So we have had conversations or internal discussions regarding obviously looking at the statute book and what is already available within those powers. Directing the terrorism legislation would obviously not be reserved, so it doesn't sit within our gift in terms of the specifics of it. Certainly from talking to operational partners, their feeling was that it would be useful to have an additional power which would look at the specific way in which organised criminality can manifest itself here in Northern Ireland. The directing terrorism offence is phrased slightly differently. I don't have the provisions in front of me for the directing terrorism offence, but my recollection is about directing the activities of an organisation, and so we have a slightly broader interpretation. So we still think that there is merit in having the... I completely take your point around the crossover, and certainly in terms of organised crime and paramilitarism, for example, it would be our intention that these provisions could be used right across the spectrum, but we still thought there was value in having a directing organised criminality offence.
Yeah, and listen, I absolutely agree with you, and I think there's merit in this as well. So I'm absolutely not against it. I'm really in favour of it. One thing I did perturb me slightly was you saying you didn't envisage it being used a lot. I would say that it needs to be used a lot more, because a lot of these paramilitary groups are nothing more than organised crime groups, and those who are directing them need to be targeted quite specifically. And that's what really took me to the point, is there's a crossover here with organised crime and paramilitarism, and our language used when we talk about one or the other. And I mean, this new law that's been brought in, I think, could be useful for the action plan on paramilitarism, organised crime and criminality. So I'm supportive of it. So thank you, Chair.
Thank you, Doug. And I can just come back on the point around the frequency that we envisage that the offence will be used. I suppose I make that point really just to manage expectations. Certainly the evidential threshold that will have to be met in regards to directing organised criminality will be challenging. There is no doubt that it will be challenging. The individuals who direct these types of organisations tend to keep themselves at arm's length, but having the offence available, certainly from speaking to partners in other jurisdictions that do have the offence, have found that actually even just the fact of having the offence available to them means that the way in which cases are investigated or subsequently prosecuted can be worked around the fact that you have this offence and you have a very clear criteria in front of you in the legislation. So it's not that we don't envisage it being used, but I suppose it's just to manage expectations that there are challenges, evidential challenges with a successful prosecution because of the way in which these individuals operate.
Yeah, and that's understood. Thank you.
Your last kind of few comments there are an excellent segue into my questions. That's what I was going to ask you. So essentially, obviously, in order to be guilty of or to be charged with the directing offence, it needs to be proven that you're engaged in the participating offence. But as you say, the kingpins that you're going to try and reach with the directing offence keep themselves at arm's length from the things that might expose them to participation. So how's that going to work?
So this is an issue that we discussed at length when we were engaging with partners and drafting the provisions. The participating offence has been drafted quite broadly in terms of the activities that are captured within it, but then we have tightened it in terms of safeguarding by emphasising that participation needs to relate to criminal activities, and we have defined that as a serious offence of 4 years, indictable in 4 years or more. But we do, in the provisions, say that the Act, in order to participate in the criminal activities in an organised crime group, the Act will facilitate or is likely to facilitate an organised crime group to carry on criminal activities. And that is intended to capture both those individuals that keep themselves at arm's length in the space of sort of directing, but also those who might keep themselves at arm's length by, for example, driving someone to and from the crime scene, or facilitating them through money laundering, or something that is slightly removed from the day-to-day operations of the organised crime group, but facilitates them in their activities. So we think that the fact that we have that there, and the fact that that is drafted in a way that is somewhat broader, means that if you have the evidence that someone is directing the organised crime, you should have sufficient evidence to prove that they meet the threshold for participation, which is the first test for directing.
I understand how one naturally follows the other, but I'm interested in the practicalities of how you're actually going to get the people you're aiming to get through this. Have you had conversations with the NCA around this?
Yeah, so we have engaged extensively with operational partners throughout the drafting of the instructions, so primarily the NCA, the PSNI and PPS, but we have had conversations at a higher level with the Organised Crime Task Force partners more generally, but those would have been the organisations who were most heavily involved in sort of looking the iterative process that Lisa described earlier in terms of looking at provisions and having those conversations. The advantage of engaging with the NCA, of course, is that they operate in various jurisdictions, so they're able to bring their knowledge and expertise about what has worked well in other jurisdictions.
That's helpful. But just before we move on to kind of what works well, can I just check with you with regard to the participating offence? People will claim they are coerced. And actually, we've seen, apart from what we know locally, but also, the department's own kind of arm's length body in terms of EPOC has adverts that indicate people are coerced. So what happens there? I presume that's taken into account in terms of mitigating circumstances or so on, or is that just how that's going to operate?
Yeah, so again, consideration was given to the need for a statutory defence to be included, but again, from talking to partners, operational partners and PS and others, they're of the view that this is already provided for through independent prosecutorial discretion, and then common law defence of duress as well, so that can be taken account of as part of the process.
Thank you. Finally from me, I think on this, yes, two things. Mm-hmm. You've said in the paper, I suppose, the new legislation will provide reassurance to both the public and the community that addressing serious organised crime is a priority for law enforcement, therefore enhancing public confidence. I think it'll enhance public confidence if people see that it works. If they don't see that it works, then it has the potential to be damaging to public confidence. So can you tell us, I suppose, what factors did you consider in this? How are you sure it will deliver? And what are you aiming for this to look like? I mean, if you're not going to use the directing thing much, tell us what's in your mind's eye with regard to this.
In terms of sort of how
success, what does good look like? If the aim here is to bring these people down and inspire community confidence, there's potential for it to go the other way if you can't do it.
Yeah, no, of
so
course.
How are you going to ensure success?
So certainly from talking, as I say, this was an iterative process with partners, and we were very keen that we didn't bring forward any legislation that couldn't be utilised on an operational basis, because completely agree with you, Chair, that it could be damaging if it isn't used or it isn't used successfully. Certainly on the participating offence, from speaking to colleagues in PSNI, it is their anticipation that there will be cases that they will be able to make good use of the additional powers that will be available to them. So as part of the process for developing the provisions, for example, we did we had a look at previous cases that had made their way through the courts, and sort of tried to workshop, I suppose, if we'd had these powers available to us, how would they have been used? So those kind of assurances to make sure that they are operationally viable and that they can be utilised.
That's good to know, thank you. I suppose lastly, I'm going to bring Deirdre in, but just I suppose my last question on this is, look, all the time we're faced with this business of people engage in this and then say, oh, the organisations didn't sanction it. The cynical among us would imagine that there's very little goes on without the organisations saying you can do it, because I imagine individuals would pay a price were they to go off on solo runs. So how are you going to handle, how does this proposed law handle circumstances where people claim it's an individual solo run, it's not sanctioned by a prescribed organisation stroke organised crime gang?
I was just looking at the exact detail of the wording here to see if I can provide you some assurance from the drafting itself. I suppose firstly I should say, I mean, obviously the prosecutorial and the evidential gathering challenges that will be involved in this, I think sort of operational colleagues would be better placed to speak to the specific sort of mechanisms that they would use around that. But in terms of the drafting, we have a number of safeguards, I suppose, in the drafting. So, for example, for the person to be guilty of an offence of participation, the criminal activities that were capable of being facilitated by the Persons Act don't actually have to be carried out, for example. So it's the intent there that is the first element. The person doesn't actually have to specifically know any of the persons who are members of the organised crime group. So it's proving that the act that they have carried out is either a criminal activity or an organised crime group, or will facilitate or likely to facilitate an organised crime group. And in terms of the threshold that falls within that, I'm just trying to find the exact wording for you. But it is effectively that the person does an act and knows or has a reasonable cause to suspect that the act would facilitate the activities of an organised crime group. So there are mechanisms there, if you have the evidence to support it, that the person should have reasonably known that the activities that they were carrying out were going to be to the benefit of the organised crime group.
We understand, then that takes us back to the coercion factor, but it's helpful to know, I suppose, I presume that fell under discussion as you move through this, so that's helpful to know. Thank you very much. Deirdre.
Yeah, no, thank you, and thanks very much. Kate, I suppose it was just a question on what informed the definition of an organised crime group in terms of the link with the amendments that are made. And I suppose there's been a lot of discussion in terms of paramilitary groupings, and and obviously at a community level, that's probably what people see and think about when they look at organised crime, but it's obviously much wider. So I know you touched on in terms of engagement with the NCA and others, but obviously we're on an island here as well. So with the south of Ireland, I'm keen to see what engagement with other agencies on a cross-jurisdictional issue, that there's been. So even in terms of how some of these groups would bank, they may be in the north of Ireland, but they may be banking in the south, or they may be banking across the water. And I suppose what engagement or how this would work then at a European level. And are there any things coming out of the Windsor framework then that may implicate, that may have an impact on this work and on the definition? And I suppose I wanted to ask a quick question around the flexibility to change this as we're moving forward, particularly in terms of the potential of online organised crime, and maybe how some of these groups will begin to develop and diversify with the emergence of more technology like artificial intelligence and others. Are we thinking of those issues? Are they being discussed, more broadly? across these islands or indeed at a European level, you know, that we may need to look at this in the longer term as well, and actually would change our definition of what we see as organised crime groups.
Yeah, no problem. I'll try and address those in order. So in terms of the definition, just to reassure members of the committee, the engagement that we had was both with operational colleagues locally, with colleagues in Scotland, England and Wales, and also in Ireland. So we did speak to colleagues there and had quite extensive conversations about how the provisions are operationalised there. In terms of the definition that we have gone for, there is good alignment across other jurisdictions, and we thought that was important, particularly given the cross-border nature of organised criminality, which we're acutely aware of, and the ability to be able to future-proof some of that. In terms of the future-proofing, also something we're very cognizant of in terms of the evolving nature of organised crime. So we have included a power to amend the definition of criminal activities, which really is the linchpin within the legislation to define what participation looks like. So that would be subject to affirmative resolution by the Assembly, but there is a power there that if in 5 or 10 years' time we feel that that needs to be updated, that could be done. Just on the cross-jurisdictional nature or the cross-border nature of organised crime as well, you'll see within the provisions that we have provided mechanisms that recognise that not all of the activities of the organised crime group need to take place within Northern Ireland in order for them to be applicable as part of the evidence for this. So completely agree, it's a very good point, and one that we're very aware of. That cross-jurisdictional nature of organised crime has to be built into this, otherwise it will only be workable up to a certain point.
Okay, Deirdre?
And I suppose I was going to anything in terms of the Windsor framework at a European level that may be coming down the line or have implications because of the framework then that you're aware of or not, maybe?
Apologies, Deirdre, I missed that one. So we have done an initial screening against the Windsor framework, which we have run past DSO, and they don't have any concerns at the moment, but we are actually in the process of doing a more detailed screening against the Windsor framework, and if there's anything arising from that, we can bring that back to the committee.
No, that's great, thank you.
Can I check one thing, Katie, just about, you talked about kind of the other jurisdictions. The census that you're proposing, how do they compare with the other jurisdictions for similar offences?
So,
and then I'll bring you in then, Justin.
We, the proposed sentencing that I do actually have a nice table here somewhere with the comparisons I'm just trying to desperately find. So we obviously have proposed 10 years or a fine or both for participation, 14 years or a fine or both for directing. If you compare that across the other jurisdictions, so comparable tariffs for Scotland, they are slightly higher in Ireland, so participation is 15 years and directing is life imprisonment in Ireland, and slightly lower in England and Wales. So they don't have a directing offence, so there isn't a direct comparison for that. But in terms of participation, their maximum tariff is 5 years, so against our 7. So broadly comparable, but there are some slight differences across them.
Well, thank you, Justin.
Thanks, Chair. Thanks, folks. In terms of organised crime and legacy, and historically, we've obviously recognised that there were terrorist organisations who were very heavily involved in organised crime, racketeering, armed robbery, kidnapping, extortion, IRA and UVF, both involved in the same business, if you like. How does that relate to the legislation in terms of proceeds of organised crime, and where the proceeds of that organised crime still exist How does that tie into legislation, if at all?
So in terms of the proceeds of crime, the consequential amendments that you can see in the draft instructions mean that the offences would be applicable for POCA legislation. So effectively, POCA legislation could take account of these offences when considering whether proceeds of crime could be brought forward as an additional mechanism. Does that answer your question, Justin? Sorry, I'm not sure if it doesn't really address the legacy point, but I suppose I wasn't entirely clear.
Justin, hello? Can you hear us?
Yeah, I'm here. I'm pausing to see if you digress further. I'm just curious to know where this legislation sits in relation to historical proceeds of crime, bank robberies, for example. How does this legislation fit with that?
I would have to check how the current POCA legislation deals with legacy. The current POCA legislation deals with legacy offences. I actually don't have that information in front of me, but I'm certainly happy to write to the committee with the detail of that. I don't have the detail of the POCA provisions in front of me, I'm afraid.
Justin, are you content to receive a response to that in writing?
Please, yeah, thank you.
Thank you. That seems to be us for now on serious organised crime. Does anybody have anything else they want to flag up or ask? Speak now or hold your peace till we need to get them back. No, everybody's fine, lovely. Do you guys have anything you want to add?
No, I don't think so. Just that we're obviously conscious this is a new policy area, so happy to come back and brief you in more detail at any point if that's helpful.
No, we really appreciate that, Kitty, because obviously as we take evidence, we anticipate issues might arise that we'll need to just recheck with you again. That's great.
No problem at all.
Team, do you guys have all that you need on this? Lovely, thank you. Katie, much appreciated, thank you. We'll move on to Access NI now.
I was tempted to say that
Brian?
you've been left with the Statler and Waldorf of the department, but Brian's definitely nowhere near as grumpy as I am on a daily basis, so it's not a good analogy. Brian, if I understand your title correctly, is Operational Manager of Access NI, has extensive experience, similar sort of career length to myself, so he's definitely the best person to talk to about all matters of Access NI disclosure.
Thank you. Brian, if you have anything you want to kind of say to us, or do you want us to go straight to questions, or what way are you?
A few opening comments, if that's okay. You probably know some of this. I mean, just to say, I think this is the first time somebody from Access NI has been before this committee, so hello, and grateful for the opportunity to share a little bit about what we do in Access NI. I'm here today to talk about the list of specified offences, the work we've been doing with regards to this list of specified offences, and just to say that this list is an integral part of the Access NI filtering scheme. It sets out serious, violent and sexual offences that essentially cannot be filtered from standard and enhanced Access NI checks. Aside from a few very marginal changes, the list hasn't been reviewed since it was first introduced back in 2014, and the department commenced the current review of the list back in 2023. So in the review, among the things that the review has found is that the manner in which the offences are presented in the Police Act, it's difficult to navigate, it's not user-friendly, particularly when the Police Act references offences in schedules in other legislative instruments, which then reference schedules in other legislative instruments. So we're really talking about looking at lists of lists here when we're trying to identify the offences that should not be filtered. We identified in the review that there were some risks to the Access NI filtering arrangements themselves. The risk that Access NI might not pick up if new offences were added, by example, by another department to these schedules that they were managing. And that might mean that Access NI might filter these offences when they really shouldn't be filtered. So that risk was a real risk for the Access NI operational environment. The review identified that the maintenance of the list was inconsistent and arguably disproportionate. The review identified that there was a need to ensure there was a regular review of the offences on this list, not something that happens once every 10 years. And the review identified that there were a number of new offences that could have been added to the list since it was first introduced. And finally, we recognised that there were some opportunities to reduce the size of the list as it's published on the NI Direct website. The proposals in the review were subject to a public consultation in the summer of 2023. And essentially, the provisions in Clause 29A of this Justice Bill seek to amend 113A of the Police Act to implement the improvement proposals emanating from the review. The amendments seek to streamline arrangements for maintenance and ease of understanding of the list and to provide greater clarity in this area of the Access NI work. I'll stop there, and if there's any questions, folks.
And thank you. I didn't realise that this was the first time anybody from Access and I had been here, so you're very welcome. It's really good to have you with us. Hopefully it hasn't been as bad as you might have thought. Or as bad as they told you. We're really not that bad.
I'm saying nothing.
I know, say nothing to your mind out, quite right. So does anybody have anything on Access NI? Ciara?
Just one immediate one would be in relation to, you had mentioned obviously the list, and there is the links then to other legislation and to make it easier. But then you also says at the end that you're trying to reduce the size of what's published on the Access NI website. So I'm trying to understand how you're able to do that by making it easier, clarity. I would have been an Access NI helper group in my day.
Okay.
So I would have been there to start doing all the training, facilitating, reviewing that list on a continuous basis for organisations and groups, and I understand the links. But how are you going to reduce it?
So on the published list, an example would be Section 4 of the Misuse of Drugs Act, supply and production of drugs. There's 125 entries on the current published list for that one provision in the Misuse of Drugs Act. We're going to shrink it down to one entry and just call it supply and production of drugs. The current list lists all these different types of drugs, cocaine, heroin, whatever it might be, and we don't think it's necessary. We're just interested in Section 4 of the Misuse of Drugs Act. If that's what somebody's convicted under, that's what we will retain on their disclosure certificate and disclose.
I think the benefit is that you're looking at one place. When Legislative Council were preparing these provisions for us, they used a term which was very helpful in setting the picture as to how difficult it is to navigate at the moment by describing it as a Russian doll exercise, where you click into the list directs you, as Brian said, to a schedule of offences. Within that schedule, there's a link to another series of offences. So you need to be an experienced practitioner of legislation to be able to follow those threads, whereas this, and there is a direct link across to rehabilitation of offenders legislation, which I'm responsible for, in terms of maintaining the original intention of the legislation, which is to offer certainty and for it to offer ease of understanding. So the two pieces of legislation they dovetail in quite a lot of ways. So the changes that Brian's talking about here to the Police Act will also be replicated in the rehabilitation of offenders legislation. So it's about making it easier to manage from a departmental perspective, an Access NI perspective, but also much, much easier for an end user to check themselves. A member of the public who might have a conviction could check themselves much more easily than they can do at the moment. You know, they might be directed to Citizens Advice Bureau or NAACRO or to their own legal representative in order to seek clarity as to around their offence could or couldn't be filtered at the moment. And are all of the members familiar with the filtering scheme and what it does?
So Shall I?
Yeah, please.
It used to be that Access and I disclosed every conviction about everybody going back any number of years. There was a review conducted in 2011, and one of the recommendations was that old and minor convictions should be removed from disclosures before they're issued. In the legislation that came forward on the back of that review, old and minor was determined at about 11 years. So if a conviction is more than 11 years, then it's considered for filtering. There's a couple of exclusions. If the conviction resulted in a custodial sentence, it's never filtered. Or if it's on this list of specified offences, if the offence is on this list of specified offences, it's never filtered. So the list's quite extensive. You see it in the schedule that's been presented. So there's a lot of serious offences that are included there.
Just a second one then, just in relation then to the changes, I suppose what, if any, financial implications as for Access and I, and is there any unintended consequences of reducing down, as you say, the specifications regarding the filtering process? I'm sure that's maybe done electronically, so as there IT implications, so just implications and unintended consequences, have they been identified and what they are?
I mean, we're really taking what's in the Police Act and trying to simplify it, or what's in the Rehabilitation Order and trying to simplify it to make it easier to run. We don't envisage there being any cost or even savings as a result of doing this. It's just about making things a little bit more easier to understand. Unintended consequences, again, we're taking something that's there and we're just changing it around. We don't expect there to be people that will find more convictions being disclosed or less convictions being disclosed as a result of this. We would like to review the list further. We want to create a committee to start to look at the convictions on the list and decide, is it right that they continue to remain there going forward? So that's part of the provisions that we're creating here when we talk about the department consulting with representatives from the Department of Health, from PSNI, and with the independent reviewer, so that we can look and say, for example, a very common offence might be criminal damage. Criminal damage is a specified offence. It's always going to be disclosed. If that criminal damage was perpetrated by somebody 16 years old, it's always going to be disclosed. But if we remove it from the list going forward, if this new committee agrees that that's what we can do, then that might have consequences for those individuals who had convictions such as that.
Okay, Ciara?
Yep.
Thank you. I just have a couple, Brian, if that's all right. Yes, the new offences under serious organised crime, presume they're going to be included in your whole process.
It'll be for Katie and colleagues to let us know about if that's what they want to do. But yes, that's the way it tends to pan out. Yeah.
But it'll be covered. When it's not that you've kind of missed that. It's
No. There's a continuous review process. Anytime there's a new offence and penalty created in statute, it's considered for biometric retention purposes. It's considered for Access NI disclosure and rehabilitation purposes, and there is a third purpose which my old man memory won't let me recall, within Policing Policy and Strategy Division. It'll occur to me at some stage tonight, but it's...
That's okay, you can message us, we've all been there.
I wouldn't suggest starting to contact you at that stage. I was like, oh, by the way. But it's to reassure you that there is a formal process there that's intended to capture any new offences and penalties that are added to statute for those purposes.
You know, Brian, if I can direct your attention to paragraph 6 of the report. I don't know if you have the report that came from the department does, but it talks about... The Access NI approach could result in the remote possibility of a conviction being wrongly filtered from a disclosure certificate, and that this could lead to a challenge, albeit unlikely that an individual would challenge the removal of a conviction from their disclosure certificate. But I'm thinking, for example, for potential employers or something, it could be a big risk, if stuff. So, in any event, and in keeping with Access NI practice, the case would be referred to the police, who could then include explanatory information as appropriate, thereby reducing further the risk of an erroneous disclosure certificate. So, I suppose, in order for that risk to be reduced, we need to have some understanding of a baseline for the number of times it may have happened. Also, how many of these do you anticipate? To what extent is this going to be considerable additional work for the PSNI because that may have resources implications for them.
We do it anyway. So if Access NI, in the current process, if we're looking at offences and we're removing offences because they can be filtered, we will send that referral to police anyway, and we'll say, look, is there anything in the background of this offence that you think merits it being retained, and maybe information added as part of police information? So it gives us that safety blanket that we're not missing something there. So we do that anyway as a part of the overall filtering scheme. This risk goes back to the entry on the current list. Any offence involving injury or threat of injury to another person. Our preference is that the list actually includes the offences, not some vague description about any offence that might do da-da-da. So what we would argue is that if offences result in injury to another person, they're on the list. You don't need that statement, and that's really what we were saying there, Chair. That statement's not really required in the list going forward because the offence will be on the list.
And in terms of the filtering, is this an automated process, or is it a process that people have eyes on? Because you're saying we do this anyway, we go and ask the police, but maybe if things have been erroneously removed, are you always checking? Do you take a random sample to see? I mean, how do you ensure that what goes to the police, what needs to go to the police, goes to the police?
I mean, it's a manual process. Our staff have eyes on, and they apply the filtering rules to convictions as they pull them off PNC. There is percentage checks undertaken against the work of staff. Higher percentage checks working their way down to, I think, 15-20% for those that are more competent in the work that they do.
So, just to go back then to my previous question, you say you do this anyway, and there may be some teething issues with this, there may not be. Do you envisage in the long term that the changes to the filtering process will result in additional burden for the PSNI?
Not with these changes we're proposing here.
Okay.
If we were to make a change down the road around the filtering scheme, perhaps instead of 11 years where they're being filtered, we'd reduce that to 7 years, and we haven't got plans to do that at the minute, then that obviously might result in more cases being referred to police at that stage.
So you don't envisage your resources impact there? No. All right. I just have a couple of other things. I noticed as I was going through the list of offences, there are a lot of references to girls and girls under 16 and so on, where there aren't references to boys. So there's it specifies, abduction and kidnapping of girls, but doesn't mention boys. It talks about prostituting girls, but doesn't mention prostituting boys. Likewise, in the human trafficking arena, there's a lot of mention of sexual exploitation and much lesser mention of forced labour. Is there a reason behind that? I mean, is there are we missing something? Are there gaps then? Does this make it, I imagine these offences are more likely to happen to girls potentially than boys, but they're still going to happen to boys. So are we sure they're covered?
It's probably really a department for or question for policy people in the department, if I may say. We're simply pulling offences off the legislation that's there.
So immediately my face turns to Andrew.
sorry, Andy.
Well, I think I'm safe in saying that the references to those offences are offences that already exist in statute. They're not general offences or offences. If it refers to an offence specifically in relation to a girl under 16, it's because the legislation, underpinning legislation, makes that a specific offence, whether it's in the Sexual Offences Act, the Sexual Offences Order, whether it's part of a criminal justice order. I couldn't speak to what the intention behind there being that specific offence and not an equivalent offence for other sexes or other ages, but I would say it's about capturing offences that already exist rather than a generic umbrella term.
I know, but I think that the prostitution of young boys already exists. I think that the kidnapping and abduction of young boys already exists. So I suppose I'm asking,
why are those offences not there?
Yeah, and are they going to be looked at? And why is there a greater emphasis on one than another? Now there's a spotlight on women and girls, but in general terms, I think we need to be protecting young people. We need to be protecting those who are in forced servitude as well as being sexually exploited because they've been trafficked. So is there any intention from the department? Okay, it's been flagged up in the course of Access NI filtering policy, but is there an intention to look at that? The boys maybe aren't being, young boys aren't maybe not being protected in the way that girls are?
It's not a piece of work that I'm familiar with, or it wouldn't come within my remit as part of criminal law branch, but colleagues in criminal policy unit who have responsibility for sexual offending offences, I could certainly have a conversation with them to see, is this something that's on their radar, and if not, if it is something that senior colleagues wish to consider, and with a view to answering the questions that you've asked. It's not something I can personally address today, but certainly happy to have the conversation when I go back to the office.
I think I would just be interested to know, does that mean we have a gap there? That's all, and maybe do we need to address that gap if it exists?
Is there gaps in legislation that need to be considered?
Yeah, some of it's from 1956. Thomas is just saying, so that perhaps explains some of it. But just when we're looking at these things,
I think you need to be careful too in reading things in sequence, because there'll be offences that have been brought in, perhaps in the 70s, which have then been repealed and superseded with other gender-neutral terminology in the 80s, 90s or 2000s. So, as I say, there's, again, I have a working knowledge of some of the sexual offending legislation, but it's not that in depth. But
it's not your area. Happy
to pose the question to colleagues on the basis that it's a concern you've expressed today.
No, that's great, Andrew. Thank you very much. Appreciate
no problem.
That. Okay. Does anybody have anything further on the Access NI filtering? No. Does anybody have? Has the team got all they need? Mm-hmm. Yes, our bases are covered. Does anybody have any other general questions that have arisen in the course of what they've heard today that they want to put to the department officials now? Everybody's good? Right. Thank you very much. Gents, that's great.
Sure, I wondered if in mentioning earlier, I talked about deadlines and indicative deadlines and our failure to meet in a couple of instances. I mentioned the Delegated Powers Memorandum, which was one that we were slow in bringing to you. The other area that I'm conscious we haven't met was the indicative timeline for giving you the text of the Live Link amendments by the end of the calendar year. I take it from the gesticulations that you have now received them, because I wanted to say that if heads need to roll, I'm happy to say that I'll put my name forward for early retirement if you haven't got a copy of those amendments in order to inform discussions on the Live Link amendments next week. The covering letter will make clear that this is a working draft that is at a significantly advanced state of preparedness, but it will still be worked on further, and by the Friday the 31st of January, and this is when I really will hang my hat on, you will have a version, further refined and finalised version of those amendments capable of being published as part of your call for evidence process.
Andrew, here's the thing with all this. We're fine with it. We want work to be done and to be done right. So we're okay with that.
Yeah.
I suppose where we take a bit of exception is then we're trying to factor these things in.
Yes.
Because we get one date that we can ask for an extension. And if we don't hit the date,
yes,
there's no redo.
Yeah.
You know, there's no mulligan in this. So for our point of view, where we were coming at it was, well, you know, we need to build in some flexibility because we don't know, and more than that, we didn't know the scale or scope of what was coming necessarily.
Yes.
You know, so we needed to afford ourselves a bit of time because there's always going to be slippage. There's always going to be things that arise.
Yeah.
So, you know, we're never going to crucify people over that, provided we know what the issues are.
Yes.
But we expect then in return that the department doesn't come after us for trying to allow a bit of flexibility into the system and to allow us to do our work properly. We want you to get the chance to do yours properly, and we want the chance to do ours properly, and
Well,
that's all.
I think in this instance, not to go into the detail because it's, I could explain what has happened and why. I don't want it to sound like excuses, but essentially we lost 2 weeks at Christmas. We could have produced a version, but we wouldn't have been that confident that there wouldn't have been issues identified with it if that was the version that had been published.
Honestly,
so
we're okay with that. We're genuinely okay with that.
In actual fact, your judgment call in holding the call for evidence until February worked in our favour because in the interest of producing the best possible amendment that we could, you gave us an extra 2 weeks, which means we're meeting your deadline for publishing something which isn't going to identify or have stakeholders identify a lot of issues with.
Our issue is, look, let's all just get this right.
Yes.
You know, so we've no problem with that if we're kept apprised of what's happening, and that people are trying to get the thing right.
Yeah.
But we do. I must say, like, we all take exception then whenever the department says to us, "Well, you're being ridiculous." Well, you know, it's the Donald Rumsfeld thing. We don't know what we don't know yet.
Yes.
So,
you're absolutely right.
So that's where we are with that, and that's fair enough, Andrew. And we appreciate your candour in that. Thank you.
No problem. I will see you next week because I'll be talking specifically to the rehabilitation of offenders amendment, so look forward to more conversation then.
We'll see you then. That's
Okay.
great. Gents,
Thanks,
thank you
folks.
very much for your time. Have a lovely
You're very
weekend
welcome.
whenever it eventually begins. Okay, members, could I ask you to note the papers from the department and the 2 research papers and the responses from the Northern Ireland Human Rights Commission and the Northern Ireland Office? Are members agreed? Thank you. As previously agreed by the committee, then the papers will be published on the committee's website. Agreed?
Agreed.
Thank you. Members, can we also agree to forward the amended delegated powers memorandum to the examiner of statutory rules for information or comment as appropriate?
Yep.
Agreed, thank you. Just to advise members too, the Children's Law Centre had been scheduled to give evidence today, but they requested that that session would be postponed to allow more time to prepare. So committee staff are going to liaise with the Children's Law Centre to rearrange the session for the earliest opportunity. Okay? Thank you. Agenda item 5 then is the Fostering Placement and Fostering Agency Regulations Northern Ireland 2025. It's a Department of Health written paper. I'd ask members to turn to pages 108 to 150 of your meeting pack for the papers. You'll see this is a written briefing from the Department of Health advising that it plans to make a statutory rule under powers conferred by the Children Northern Ireland Order 1995 and the Health and Personal Social Services Quality Improvement and Regulation Northern Ireland Order 2003. It's proposed that the rule will be subject to negative resolution procedure. The Department of Health has advised that the SL1 will be considered by the Health Committee, but that because the rule proposes to introduce offences, it's also being shared with the Justice Committee. There's no detail in the Department of Health's letter outlining what the proposed offences are going to be. Or whether there be potential penalties and what their implications might be. So can I seek your agreement that we ask the Department of Health to provide more information on these matters?
Yep.
Great. That's great, thank you. I am having a slight administrative problem here. If you'll just bear with me for a second. Because my chair's brief is only going up to page 7.
Right, okay. Okay.
No, it's okay, I'm fine. I'm fine. Sorry, right, yes. Apologies, members. I knew that my chair's brief ran to 11 pages and I or sorry, to 12 pages, and I only had up to 7. And
You've got them now.
I can honestly say the sweat broke on me there.
That's okay. That's okay.
So now we're sorted out. Thank you, and apologies for that. So we agreed that the next thing then is agenda item 6, which is enabling access to justice reform programme and an update from the Minister of Justice by way of a written paper. It's pages 152 to 155 of the meeting pack for the relevant papers. You'll see that the Minister has provided a written update on the enabling access to justice reform programme. Are members content to note the written paper, or do you require any further information? No. Can I say I'm glad to see this? I am genuinely concerned that we're heading towards a crisis in terms of access to justice for lawyers who engage in legal aid work. So I'm really glad to see that there's movement on this, and it needs to continue at pace, because Northern Ireland's going to have a massive problem. There are vacancies in solicitors' firms, and there have been vacancies in solicitors' firms for years because nobody wants to do this work. So this is a very serious issue coming down the track to us. Deirdre?
Yeah, no, thanks, Chair. It's just with regards to that point, and obviously some of the industrial action and stuff that's taken place as well. So, I mean, the update is useful and good, and it is something we've been raising as a committee. But I would be keen to see what engagement the Minister and the Department have been having directly with the sector, both the bar and the lawyers themselves and some of the direct firms, and particularly to try and avoid any further action if, you know, something can be done. So I'm keen to just get a wee update in terms of actual meetings or engagements that have happened or that will be taking place over the next short period.
Okay, so your proposal is that we write and request that information, Deirdre? Yes?
Yes.
And before we agree that, I'm going to take Justin, because I presume it's on the same point. Go ahead, Justin.
Thanks, Chair. Very quickly, I just don't see in the Minister's letter the issue of the Department's policy of payment delay addressed, and I think we should seek clarity on that front in terms of access to justice.
Explain to me, Justin, is there not something in that about the 16%?
No, that has to be consulted on, and there's 3 legislative points, and she is saying in her paper it'll be June, summer. There's no immediate swift response regarding the financial as the recommendation, but she wants due process to take place. So she's noted consultation process, etc., and she would be hopeful that this could.
Yeah, but
be sorted
just
by the
in terms
summer.
of Justin's point, though, what I'm trying to establish is it may not be referenced in the letter, but it's in the very. I presume that she was working on the basis that we're more or less going to be considering the 2 papers together. Justin, do you want to action this, or are you content that, you know, because of the next set of papers we kind of understand what?
Okay, as long as
was there another point?
The issue of policy, the Department's policy of payment today is addressed through this process. That's fine.
Right, Justin, could you say that again? I missed that.
So long as the Department's policy, the Justice Department's policy of payment delay is addressed through this process.
Understand,
in terms of
Cathy?
access to justice.
Understood. Kathy, you want to come in?
Yeah, I think, Chair, what Justin is referring to is actually a policy, not a policy, it was a budget management tool, I think, maybe that the department was using in terms of delay in paying some of the legal aid. Is that what you were referring to, Justin?
Yeah.
Yeah.
Well, I would call it a policy of payment delay, but you might call it a budget management tool.
That's what they call it, a budget management tool. So,
okay.
I think if we write on that, Justin, we're going to be told there's a consultation document, and it'll be, you know, unless there's. I mean, are you content that we follow through on that because of through the consultation responses when we hear? Okay, I envisage there are going to be issues with the 16% across the board, and I expect that's what the consultation is going to throw up, but we'll see. Deirdre, do you want to come in again?
It was just, I suppose, feeding on from Justin's point, because I'm trying to remember when we had the briefing before Christmas on the proposed interim payment. I know the Minister in her speech to the Assembly had said she wants to look at legal aid in the round, but there may be this short-term interim payment coming forward. And there was a table given to us in terms of, but my understanding that was going to be before June. So is there a delay in the consultation? And when would that payment be forthcoming, I suppose? Is there a bit of clarity that can be given on that?
I think we could include that in the letter. Couldn't we? Kathy, what was your point there? I'm sorry.
Sorry, Chair, I was just saying that we're
budget
making
briefing.
arrangements for a budget briefing because the draft budget is out, and questions like the delay in legal aid payments could be considered at that point with officials at that point.
So we can include it in the letter, and also we can address some of this stuff with officials whenever they're coming on the draft budget. Content? Yeah? Does that cover you, Justin?
Yeah,
Cover you,
consent.
Deirdre?
Thanks, Kathy.
Right,
Thank
that's
you.
great. Okay,
Very
thank
good.
you. Agenda item 7 then is amendments to legal aid remuneration, proposals to amend remuneration for civil and criminal legal aid services for solicitors and barristers, and the consultation. And that again is the DOJ written paper at pages 156 to 288 of the meeting pack. So you'll see this written briefing from the department regarding its plans to conduct a consultation on proposals to uplift civil and criminal legal aid fees following Judge Burgess's fundamental review of criminal legal aid. Are you content to note the paper and to consider it further whenever we get the responses from the consultation, or do you require any further information, clarification, or anything else you want to do with that just now? The only question I have is when's it starting? The papers that we received didn't tell us when it would start. It says January, but we don't know when. We know it's 8 weeks, I think, but we don't know when it commences. So are members content that we would ascertain what the starting date is and therefore the closing date? Thank you. Yeah. Agenda item 8 then is the Aarhus Convention. I have no notion if that is the correct pronunciation, but we'll try that one anyway. Access to justice in relation to the Aarhus Convention, call for evidence, DOJ written paper. Again, that's at pages 289 to 325 of your pack. So that's a written briefing from the department regarding its plan to issue a call for evidence to seek views on the Aarhus Convention Compliance Committee's recommendations on access to justice in order to inform the best way for Northern Ireland to be compliant with that convention. Are members content to note that paper and consider further when the results of the call for evidence are available? Does anybody have any further information or queries at this stage? No? Thank you. Forward work programme then is agenda item 9. That's at pages 327 to 336 of the meeting pack. Members content to note the forward work programme? Please note, obviously this is not tablets of stone and things are subject to change as agenda and availability dictate. Content? Thank you. Agenda item 10 then is correspondence. So there's a correspondence memo and 25 items of correspondence at pages 337 to 542 of your meeting pack. And there's one item at pages 25 to 26 of the tabled pack. Members, I'm going to draw your attention, as I usually do, to a number of items, and then I'll open the floor if anybody wishes to comment on any other items of correspondence in which they have a particular interest. So first of all, if I can draw your attention to item 10.4, which is correspondence from the department at pages 402 to 412 of the meeting pack, and that's a departmental return to the Department of Finance in preparation for the draft budget. Could I ask your agreement to note this item and schedule an oral evidence session with officials on the draft budget 2025-2026? Agreed?
Yep.
Thank you.
Great.
Item 10.20 then is correspondence from Ofcom at pages 446 to 450 of the meeting pack, and that relates to the publication of Ofcom's illegal harms statement further to the Online Safety Act 2023. Can I ask members to agree that we ask the Department of Justice to provide any details of implications for our justice system here in Northern Ireland? Yep. Agreed? Yep. Thank you.
Great.
Item 1021 is correspondence from Ofcom again at page 451 of the pack, and that relates to a proposed plan of work for 2025-2026 and contains information on a planned consultation event in the Long Gallery on the 23rd of January. So can I ask you to note this item, and also you can register directly for that event by using the link in the letter. Agreed? Thank you. 1023 then is correspondence from McGibbon Consultancy and Safeguarding Services at pages 454 and 455 of the pack. That contains a request for the committee to raise with the Minister of Justice, the Department of Justice and the constituent agencies of public protection arrangements in Northern Ireland, a number of matters regarding a murder case and the lack of a serious review. I just want to flag up that that's the first piece of correspondence, but there have been subsequent responses to and from the Minister and McGibbon. So I'll send those on and they can be included then in the next pack. You'll be aware that in response to a written assembly question, the Minister has advised that she has commissioned independent lay advisors to review the robustness and operation of the referral process to PPANI, and the Minister also advised the terms of reference for a review of this specific case are being finalised, and she's indicated that in a letter that actually came in today that she will share those terms of reference with us. So I will forward through the correspondence for the next item of agenda, but in the interim our members agreed. I see your hand, Deirdre.
Yeah, no, thanks, Joanna, and I think it's good, to share it with the rest of the committee in terms of the correspondence from Mr. McGibbon and then obviously from the Minister as well, and it was sent to yourself and myself. And as you say, as recently as today, the Minister has responded. But I think there are, genuine concerns in the case, not just pertaining to the individuals involved, but also in terms of safeguarding issues more widely. I'm conscious now I'm saying this and not everybody has received the information, but I would like to even get a timeline as to when the terms of reference for the review is going to be taking place, and those who are conducting the review, what expertise they have to conduct the reviews, and also is it going to be a review looking at the processes of all of the agencies and not just those that fall within the Department of Justice pertaining to those issues. So there are just some of the areas that I would like. Now, I'm happy to kind of leave maybe some of these actions, Chair, until next week to give other members, the chance to read the correspondence and stuff. But that's just some of the initial queries and concerns that I would have to make sure, that what did happen in the case, to try and mitigate that it doesn't happen again to anybody else.
Yeah,
thanks.
No doubt, and I'm glad that you've kind of clarified. I think that members can see from the initial correspondence, the company that's writing is doing so from a very genuine concern. It's not about having a go. It's genuinely about, look, there are feelings here and there needs to be a review, and happily the Minister has acceded to that request and has considered that there does need to be a review into this. So our members, you can as Deirdre's proposed there, we can write, but I think it may be beneficial. I'm sure nobody disputes what she's saying. I've got the correspondence and I can verify what she's saying, but it probably would be beneficial for members to see the rest of the correspondence and then write.
Yeah, I would agree with that. I don't dispute it at all, and no problem asking questions. I would really appreciate seeing that piece of correspondence before we send anything further, in case there's anything else anybody would like to add as well.
Yeah, it's very good, and actually there's really constructive dialogue in all of those letters, so I think it'll be helpful. And in terms of the general principles and making sure that the processes that are in place do what they need to do, because there's been a feeling here, so let's see what the learning is. That'll be really helpful. So we'll hold that then until next week, and then we'll take it from there. Okay, members agreed? Mm-hmm. Thank you. Agenda item 1025 is correspondence from Allied Health Professions Federation Northern Ireland, and that's page 458, and that's an invitation to an event in the Long Gallery on Monday the 24th of February. Are you content to note the item? Yes,
Yeah.
you can register directly yourselves in the link, I think. Then item 1026 is at page 25 of the tabled papers. Let me just get that up. You'll see that it's a press release relating to a forthcoming publication of a report into a death in custody that is embargoed until 001 on the 20th of January. So could I ask members to just note the press release and also take account of the embargo? Yes?
Noted.
Thank you. Does anybody have anything further they want to raise on the correspondence?
Yeah, Chair, can I raise an issue, please?
Yes, Gemma.
It's just on item 10.6 around the addendum to the Stock and Protection Act. I'm sure that like this is quite topical at the minute, as I'm sure that some, if not all, committee members are aware of the GAA catfishing scandal. And catfishing, as we know, can have a devastating impact on people's lives. And in this case in particular, it does, in my opinion, verge into stalking legislation. So in light of this and the publicity around this, I'd be grateful if could we request an update from the Minister to ensure that victims can access justice and that there's a clear deterrent to those who are, who are engaging in catfishing, to not do it, given the impact that it does have on people's lives.
Thank you, Gemma. I'm not completely au fait with the case. Is that case concluded now? No.
No.
I'm not across the detail of it. My understanding is it's allegations made on a podcast. Maybe if we could request the information you're looking for, Gemma, but not reference the particular allegations.
No, that's fine. Yeah.
I think we're in safer territory if we just stick to generalities and principles as opposed to reference anything else. So are members agreed?
Yeah.
Yeah, thank you. Does anybody else have any other issues they want to raise here under correspondence? I do. Sorry, who's going? Ciara, yes, you did.
Just two short ones. In relation to 10.7, and it's page 360 to 361 on the bail addresses. And obviously we'll welcome the range of ongoing work that is happening, particularly within the prisons, and trying to provide a wraparound kind of support service prior to release. One of the areas was in relation to the approved premises to enable additional support to be provided. Could we get further information on what makes premises be approved? Who approves them, and what's the list? Just further clarity around that approved premises list. And then secondly, it's under 10.8, page 367. Obviously review any services provided to vulnerable people detained in prison. They mentioned the RQIA and the 16 recommendations, and then referred to the Department of Health, the Strategic Planning Partnership Group, and PHA established a task force and Finish Group to address 14 of them. They mentioned the reports are done, and they're relying on the SPPG to take it forward. Is there some way we could follow that up just to see where that's at in relation to the SPPG? Is there any dates, times regarding the key actions that have come out of those 6 reports?
So are members agreed to those?
Yeah.
Yes? Great, thank you. Anybody else? Deirdre?
Yeah, sorry, I nearly forgot about it. It was just the update. I forget what's on page 365. Forget the number, sorry. It was the update on the Housing First model. And I know the department responded saying obviously that housing, which it is primarily an issue for DFC and the Housing Executive. But it was more that in the previous mandate, there was agreement for DFC, DOJ and the Department of Health to work together and a memorandum of understanding on the Housing First approach, and where it crosses over into health and also justice. So could we go back and seek clarity on that previous, because I don't know if that has been given as such. It's just laying out that it's really an issue for DFC. So I don't know if we can go back to say, are they in an MOU with the other 2 departments, and is there more information on that?
Members agreed, yes?
Yeah.
Thank you. Right, the one I want to raise is about the injury on duty scheme and the policing board. And that's at page, I want you to turn first of all to page 393 of the pack. So, our former clerk, Caroline, wrote to the department. Just around this, you'll recall, whenever we had the officials here about this, the issue was that they hadn't included in their consultation whether or not this really should be with the policing board. So we wrote to, they hadn't included this in the consultation. It seemed a fairly natural thing, bearing in mind that Uncle Tom, Cobley and all thinks that it shouldn't be with the board, it should be with the police as it is everywhere else. So we wrote to the department to say, okay, more than that, actually, the officials then said the policing board had never asked for it to be moved away from them. Now, a number of us have been members of the board. We've sat in the chamber and we've heard our colleagues flag up that they have asked, repeatedly asked. So we need to be clear, one, what the formal process would be for that to be removed from the board, and two, to clarify from the department whether or not it has received a formal request from the board, because the board maintains the deputy chair wasn't there, but at my kind of quarterly meeting with the policing board, they're fairly adamant that they have, and the department's well aware of this. And you'll know from listening to our colleagues that seems to be the case. So we've received a response from the department that talks about the complex nature of the tripartite arrangements and the injury and duty steering group, and some confusion. But I actually think there's some confusion around the question that we're asking, which is clarification around, okay, well, has the policing board asked or not, because they maintain they have, and how, if it were to be removed, how would that happen? What process needs to, does that help? David, I appreciate that these things always end up with you. Does that clarify?
Yes.
So essentially what I'm seeking then, members, is that we would circulate that response, our initial letter and the response, to the policing board so that they can see, because it was raised with us at our quarterly meeting. But also then that we write again to the department seeking clarity on those two specific points. Are members agreed?
Agreed.
David, that's great, thank you. David, is that okay? That's lovely, thank you. Right, nobody else has anything on the consultation then? Just me, consultation, correspondence. Right, members content to note everything else? Yes, thank you. Members, an email was sent on Tuesday of this week, the invitation from Amnesty International to an event in room 115 in here on Tuesday the 28th of January regarding the current position on legacy. An email was also forwarded on Wednesday regarding a drop-in event being hosted by Queen's University in the Long Gallery on Tuesday the 21st. So members, you can respond directly to the relevant organisation should you wish to attend either event, okay? Agenda item 10 is chairperson's business, of which there is none. Agenda item 11 is any other business. Does anybody have any other business they wish to raise? No? Then members, thank you very much. Agenda item 12 is date, time and place of the next meeting. So that's going to be Thursday the 23rd of January at 2 p.m. in this room. Thank you very much, everybody.
Committee Room 30, Sound. Committee Room 30, Sound.